matters pertaining to previous court. If your lordship can say that put at any time, item number 30.
30.
2.
Your others, you have to inform the state. We will take it up at 1. Actor Shoman. 1. Yes.
Miller, time for the appellant Miller. So this is bill in connection with appeal Miller.
Yes. Yes.
Mallard, I appear on behalf of the applicant, my lord. Mallard, since application with the pair for bail in direction of the appeal, my lord.
Mallard,
This should be appeared today, my lord.
this was due to appear today.
Due to appear today.
Was there any direction?
This was filed and date was put for today.
Hand over the slip, it will definitely appear tomorrow. Yes. Yes.
Failing condition.
Yes.
Failing condition.
Yes, please.
Mallard, whether we appear tomorrow.
Whenever the file comes, definitely it should appear tomorrow. We don't have any control over the file. But since you have handed over, we don't keep matters pending. If you take mentioning, we give it in the list. Yes.
Madam, inclusion of the state advocate made in the CRADB 61 of 2024.
Whose name? What is the name?
Daniel APC.
Name? He never appeared even on one occasion before us. I have deleted that name. Why did you put in the name? Mr. Adit Shankar Chakrabarty has not appeared once in any of the matters till we came in circuit. His name won't be included. And whenever you put it in, we'll delete it. Is there any fun in that? He doesn't appear in the court. He was not online. He was not physically present. We have not seen his face after coming to the circuit. Don't forget this practice. It cannot be included just like that. Nobody's name. Nobody is above the law. He has not appeared in a single matter before us. Not a single matter before us. In at least 10 matters, 20 matters every day, we are seeing his name included. Why? Some of the matters we did nothing. But yes, now we have interdicted. If he does not appear, his name does not come in. Call on the list. And this should be a clear message to everybody concerned. However high he may be or she may be. Yes. Yes. Why to be mentioned?
In the order sheet project, order dated May 2025.
Or that dispose of.
Yes,
Achha.
Lordship.
We find from it was wrongly recorded.
Wrongly written, and moreover, there was a direction passed by.
Yes, the rest of the order shows that it was.
Stay application should be heard by the single bench.
That
Kindly fix.
no, that remains in. We'll put in something in our order.
Lord, and
It is-
post the matter to next circuit, my lord.
No, Lordship, no,
Lord,
Lordship.
because I have made all endeavors to contact with my client, my lord. Lord, I couldn't get in touch with the client,
No.
my lord.
It is pointed out by learned counsel for the parties then that in the order dated May 19, 2025, passed in SAT 4 of 2023 with IA number CAN 2 of 2023, although the appeal was admitted upon hearing under Order 41 Rule 11 of the Code of Civil Procedure, and directions were given for the stay application to be listed before the appropriate single bench, by an obvious oversight, in the last paragraph of the said order, it was recorded that the appeal and the application were disposed of. Full stop. In view of the rest of the order indicating clearly that the appeal and the application were kept pending, let the order dated May 19, 2025 be deemed to stand rectified to the effect that the last paragraph, that is paragraph number 4 of the same, stands deleted. The application be listed before the appropriate single judge having determination.
Grateful.
Thanks. The application single judge আমার কাছে চলে যাবে. Next.
Lordship, in item number 2, in the
Yes.
last para on page 3 of the order, stated that the entire matter, CRADB 64 of 2024 is disposed of. However, in this matter, only CRAN 3 is supposed to be disposed of. So it's just that.
Different benches doing this.
Lordship, is a small technical.
Let just check. Yes, obviously. in the order dated July 11, 2025, passed in CRA DB 64 by 2024, along with CRAN 3 of 2025, although it is evident from the order that the CRAN was disposed of and the appeal is still pending, in the last sentence of the said order, it was erroneously recorded by oversight that the appeal itself is disposed of. Full stop. Accordingly, let the order dated July 11, 2025 be deemed to stand corrected to the effect that the last sentence recording that the appeal is disposed of stands deleted.
Grateful, Your Lordship.
Call. Yes.
Time for the applicant. DSG will appear short pass only.
No passive. Bail in connection, you are there. Yes, what is the matter?
Well, this is the renewal of the application. On the last occasion, the Honorable Coordinate Bench has directed the registry to prepare paper books within 8 weeks. But we are running in the 13th weeks, my lord, and paper book has not been prepared. So I have renewed my bail application on the ground that there is a violation of 41B because there was no
So
independent.
that ground was previously turned down.
Yes, my lord, I have.
Your only ground now can be this paper book preparation.
Paper.
Because here it is not like a first time appeal, a first time bail application. One competent court has decided.
4 weeks was directed previously, thereafter 8 weeks, my lord. Till now, my lord, nothing.
We will relegate this application to the next circuit. We'll direct the registry to immediately ensure that the paper books are prepared within a fortnight. We'll keep this application pending, not decide it right now.
Yes. My lord, petitioner is in incarceration for more than 2 years, my lord.
Understood,
And
but
criminal antecedent against this petitioner. my
no,
lord.
but that test has been tested in the previous order. So if we do it, now we have to dismiss it again on the same ground. We don't want to do that. That's why we are directing the office to do it within 2 weeks. Learned counsel for the petitioner appellant stroke petitioner submits that the appellant is already in custody for more than 2 years. First up, it is contended that by a previous order dated April 9, 2025, a similar application for bail in connection with appeal was rejected. Full stop. However, the coordinate bench in the same breath, had directed the expedition of the appeal and the paper books to be prepared within 4 weeks of arrival of the trial court records. So trial court records have arrived.
We don't know.
Full stop. We find from the records that the trial court records have already arrived. Full stop. Accordingly, the paper book prepared. বলবেন তো সেটা have already arrived before this court. Full stop. Moreover, the paper books have also been made ready. Full stop. Hence, the appeal itself is now ready for hearing and be placed in the list on July 28.
Yeah. Then, my lord, let the appeal be taken up because.
What are you saying? Let us complete the sentence.
Oh, my lord, sorry.
And be placed in the list on July 28, 2025 for hearing. Full stop. In view of the appeal itself having been directed to be listed on July 28, 2025, the prayer for bail loses relevance. Full stop. Accordingly, CRAN 2 of 2025, this is CRAN 3. CRAN 3 of 2025 is disposed of in the light of the above observations. We are not granting bail, but appeal will appear on 28th.
Deploy.
Item number 4.
Yes.
My lord, I am for the state, my lord.
State. Bail in connection with appeal.
Yes.
What is the charge offense?
My lord, I have been served my lord, the application copy without having any, my lord, the annexure, my lord, only the application.
Why?
Judgment has not been annexed.
I'm not aware of it.
300 to 498A, my lord, conviction charges under.
You are playing with a person's personal liberty. You are for the petitioner. You have not given full copies. You are not moving the matter. You have asked for bail in connection with appeal. That person is languishing behind the bar. You are so careless.
On the accommodation, I shall serve.
Learned counsel for the state submits that the complete copy of the application has not been served First of next parallel, counsel for the petitioner is requested to ascertain, there are only one annexure.
My lord, only the order, my lord, pertaining to the admission of appeal, my lord.
That is the only order annexed here. There is
Yes.
no other annexure.
No, my lord, nothing.
So what? What, the entire copy of the application has been given to you?
My lord, the impugned judgment has not been annexed.
May not be, you've produced the impugned judgment, or we can find it from the records. এটা কেটে দিন যেটা বললাম, হ্যাঁ? Learned counsel for the petitioner seeks a day's accommodation. Let the matter stand adjourned for the day. You should be posted with the papers. You are the state. Yes. Yes, Mr. Das. State is not there. Give a notice to the state side. We will take it up tomorrow. None appears for the state at the time of call. Full stop. The learned advocate for the appellant is requested to give a notice to the learned advocate for the state that the matter shall be taken up tomorrow. Full stop. Let the matter stand adjourned for the day. Give a notice. Just give a notice.
Yes.
Item number 6.
Yes.
6 manner down for the respondent, although manner is ordered for 1 rule later.
None appears for the appellants at the time of call, adjourned for the day. You please give your names. Yes.
Number 7.
Lordship, I am for the appellant.
Defect?
Lordship, I'm paying for short passover.
No passover.
Davankurpal is on.
Respondent does not have a right. Yes.
Lordship,
What is the defect?
Lordship, defect in the certified copy that not be cured, your lordship studied.
That will direct to send.
Yes, lordship. And lordship, your lordship directed to serve copy upon the respondent. Lordship, I have served section 5 application upon the,
Oh, this is a section 5.
yes, yes.
What is the delay?
Lordship, 58 days.
What is the reason?
Lordship, the appellant suffered illness, lordship, and as well as the collecting the documents, there is a delay of 58 days, lordship. That will be considered, lordship. Can one, lordship.
And one right.
Pair number 2 and 3, I have explained the.
Yes, you are for the respondent. What is your objection to this?
My lord, I'm not very well versed with this matter, my lord.
Go to paragraphs 2 and 3 right now. Can 1. Stamp reporter delay দেয়নি।
Judgment. Judgment decree trial. Yes, trial court procedure ने बोलते थे।
সে তো ট্রায়াল কোর্টে, অ্যাপিল কোর্টের তো এটা সেকেন্ড নাকি? সেকেন্ড অ্যাপিল তো অ্যাপিল কোর্ট দেখে ক্যালকুলেট করবে।
Thus, the certified copy of judgment may be sent down
হ্যাঁ।
to the court for necessary correction.
And you have not filed the certified copies of the trial court? Judgment and
But there's not, like, there's no document to substantiate the illness that they have mentioned. Yeah.
what about certified copy of judgment and decree of the trial court? You have not given those.
Decree of trial. Stand one, right?
Yes, we are allowing it. A hard learned counsel for the parties, full stop. The ground for the delay as shown in the application is that the appellant was ill for some period, after which she took some time to collect the papers and hand over to her learned advocate. Full stop. Thereafter, the appeal was prepared and filed. Full stop. Next para. Keeping in view the above circumstances and that the delay is of only about 58 days, comma, we are of the opinion that the delay in filing the appeal should be condoned. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in filing SAT 13 of 2024. Full stop. The the learned advocate for the appellant shall file the certified copies of the judgment and degree of the trial court uh, within 4 weeks.
Lordship.
Full stop. The appeal is now taken up for hearing under Order 14 Rule 11 of the Code of Civil Procedure. Yes, what is the matter? Order 41, move the appeal.
Lordship,
What is the ground?
Lordship, in this matter, Lordship, Mr. Shankar.
No. Then you should not have moved the stay application. You have to satisfy us on the ground. We won't grant you time.
Taken up on Monday, Lordship.
No. No question of that. We refuse them time, you have to move the matter now.
My lord, there is also no day-to-day explanation.
Need not be. That's settled. That's settled. Law is that you need not give day-to-day explanation.
Lordship, kindly give us a time, Lordship.
No. What is the matter? You should know. You come prepared only on the section 5, you move that and get an order.
Lordship, regarding the merit of the case, Lordship, Mr. Shankar Mukherjee will.
পুরো entire orderটা যেটা দিলাম না মেঘনাথ ওটা পুরোটা recall হবে. On the prayer of learned counsel for the parties, the matter stands adjourned till July 28, 2025. We have not also allowed the section 5. When they come, they have to come prepared on the entire matter. Getting this section 5 allowed and getting it relegated to a different bench, no, sorry. You come prepared on 28th on the entire.
Monday, Lordship.
We have recalled the entire order. We have said that on the prayer of learned counsel for the parties, the matter is adjourned till Monday.
Grateful, Lordship.
এটা ছেড়ুন অদিত শঙ্কর নামটা দেখে নিন ওই নামটা এটা ছিঁড়ুন ওয়াসিম মিশ্র যে ওই নামটা দিয়েছে ওই সুভাষিস মিশ্র নামটা দেবেন ছিঁড়ুন ছিঁড়ে ফেলে দিন আবার অদিত শঙ্করের নাম দিয়েছে চুলোর একটা সীমা থাকা উচিত সকালে বলে দিলাম আর ওই মেয়েটিকে দেখলে আমাকে বলবেন তো খেয়াল করবেন তো ওই মেয়েটি এলে আমি একদম স্ট্রেট ওয়ে বার কাউন্সিলে রেফার করবো নাম ইয়েস কল অন দ্য নেক্সট ম্যাটার
Lordship, in this matter, Mr. Sudhir Kumar Majumdar and senior counsel, the draft of paper.
An adjournment is sought on behalf of the appellant. Let the matter stand adjourned till the next circuit. Next.
One day.
Definitely not. Not every day, no. No. Next. Yes. Yes, Mr. Dhar, what is the matter? What is the defect?
This thing is the Lordship is second appeal. Lordship is the first appeal for on merits, Lordship.
This is second appeal.
Yes, second appeal. The
Yes. Defect, what is the defect?
yeah.
Let us check. You give the name of the judges of both the courts below.
Lordship.
In that memorandum, we'll give you liberty by tomorrow, do that. And this. As a memorandum of appeal from appellate judgment, not appellant judgment, make it appellate decree. These two corrections you have to carry out. Ar ki nahi bolchen?
Lordship. May I indicate one thing, Lordship? The decree has not been drawn by the. So what has happened, Lordship? The suit was filed for recovery of possession, Lordship.
If the decree has not been drawn up, you cannot file a certified copy.
Certificate copy of only the judgment.
When did you apply for the decree?
Rejected the application for continuation of delay, and accordingly, my first appeal was not admitted.
2-minute matter. But you have to, therefore decree was not drawn up. Acha. Let us check up also.
Kindly come to the order passed by the first appellate court, additional district court.
তাহলে তো ডিগ্রি দেবে না মানে ডিগ্রি জব করবে না
Delay was there
সেকশন 5 ডিসমিস করে বাড়বে লিমিটেশন ডিগ্রি ডন আপ হবে
because the may I indicate only one
শুনে
thing?
নিচ্ছি yes
Yes, only this first appeal was filed against referred against the order dated 20.
no we'll go into the merit since the appeal arises out of a judgment of the first appellate court whereby the application for condonation of delay of a title appeal was dismissed and consequentially it was observed that the title appeal is not admitted, being barred by limitation, no decree has been drawn up in the First Appellate Court, full stop, as such, comma, we dispense with the requirement to file the certified copy of the decree of the First Appellate Court. Full stop, insofar as the other defects in the memorandum of appeal are concerned, comma, leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal by tomorrow. Do it by tomorrow, give the names of the judges and memorandum of appeal for appellate decree. Yes, now let us come to the appeal court judgment. Delay of?
Delay of only 4 days.
Why refused? No, section 5 was filed.
Section 5 was filed.
Court says no petition under section 5 was filed. Oh, limitation. Section 5 was filed subsequently to the subsequent to the appeal.
20th September was the last date for filing that. On that day, it was a pen down, Lordship, in the learned court below. We could not have filed it on that day. And
The
subsequent,
second appeal will be heard on the following substantial questions of law. One, whether the learned judge of the first appellate court substantially erred in law in adopting a hyper-technical approach by refusing to condone the delay of only 4 days in preferring the title appeal. Two, whether the learned judge of the first appellate court substantially erred in law in refusing to look into the application for condonation of delay in filing the title appeal only on the ground that the same was filed after the memorandum of appeal being presented, comma, which is contrary to law. Any interim application?
so that was of the
What is the nature of the decree?
it was the suit for recovery of possession. It was decreed against me, Lordship.
So then, you have paid for stay of the appellate court judgment. How will that help you? You have to pay for the trial court's degree. Execution has been levied. We are granting stay, but we are granting you liberty. You also carry out the necessary amendment to the cost to the prayer and the cost title of the application by incorporating the prayer for operation of the trial court degree. In view of the appeal having been admitted and a prima facie case for hearing of the same on merits having been made out, there shall be stay of operation of the judgment and decree dated August 21, 2012, passed by the learned civil judge, Junior Division at Alipurduar District, Jalpaiguri, in title suit number 119 of 2006, till disposal of the application. Push of liberty is granted to the learned advocate for the appellant to carry out the necessary correction to the cause title in the prayer portion of the stay application by incorporating appropriate prayer for stay of the decree of the court of first instance during the course of the day. Push of next para, the appellant shall serve copies. How many appellants? Several. Appellants shall serve, the appellant shall serve copies of Can 1 of 2025 on the respondents, indicating that the application shall next be listed before the appropriate bench in the next circuit, subject to being mentioned before the said bench by the parties. Push up, the appellant shall file an affidavit of service to that effect on the returnable date before the appropriate learned single judge. Next. Yes, whatever corrections you can do right now. Memorandum, that memo of appeal from, and if the name of the judges you can get, do it during the course of the day. Yes.
For the respondent.
Yes, how are you?
So far, so good.
Yes, you are for the respondent, you are for the appellant. Yes. Yes.
The CAN application has not been filed. Would I have filed the CAN?
Pure procrastination shenanigan happening. Victim ordered in my favor, my lords, reinstatement.
No stay has been granted. No stay has been granted, so.
Only 2 copies of the writ petition required, or we will file it. During the course of the day, let it be taken up tomorrow.
You cannot file their stay application.
No, it's not about the stay application.
They want to file it.
They have to file everything else.
CAN
That is how it is defective.
for stay, sir.
Very well. Learned counsel for the appellant submits that the application for stay has only been filed today. Push up, liberty is granted to the appellant to mention the application, to furnish the number of the application for it to be listed along with the appeal. Full stop. Have you got a number? Give your number whenever you get it. Our officer will put it on the list. The matter shall next be listed on July 28, 2025. It will appear on Monday with the application. Give the number today. Dile otar songe eta dibe. Thank you, Mr. Mayor. Mr. Mishra, please give ask your yes, and your appearance also.
For the respondents.
Yes,
Matter was restored on the last occasion by your lordship.
very well. What is the nature of the appeal? This is an application now before us.
No, my lord, the appeal is pending.
Appeal hearing it's very difficult for us to take up. We'll take up the death references. What is the appeal against?
It is
The nature of the order.
It's seeking regularization from the post of peon in a madrasa.
In a?
Seeking
In a madrasa.
regularization from the post of peon in a madrasa. Just contractually appointed as a peon.
Is it a short matter? Can
be taken up in course of next week, my lord. Story there.
what is that? What is your ground of challenge? What has been done?
But
You are for the appellant.
I'm
Oh, you are for
the
the. Acha. He's there. So you are asking for time, or you will move the matter? On the prayer of the appellant, let the matter stand adjourned, be listed next week. Listed on Monday. Monday, January 28, 2025. Yes. Next. Mr. Rai, for the respondent, none appears for the appellant at the time of call, although the respondents are represented. Yes. What is the matter?
So I'm led by Mr. Hirok Burman, lordship.
That cannot be the matter.
Lordship.
Will you do the matter?
Yes, lordship.
What is the matter about?
Passed over, lordship.
Learned Counsel for the State Stroke Appellant seeks an adjournment. Let the matter stand over till July 28, 2025. Give your appearance. Mr. Borman's Junior, please give your appearance. Not Mr. Borman, your appearance.
No, defective.
No. Some people are not appearing. They have not even once appeared throughout the till today. This is the third day. Third day. And these practices are giving a bad name to us, to the entire judiciary and the bar. Yes, next.
In this matter, I am appearing for the Siliguri Municipal Corporation.
Please, my lords, I beg to appear, my lords, for the appellant petitioner. Your lordship will recall this was taken up on Monday and your lordship had passed.
Yes. Yes, Mr. Mitruka.
Mitruka. Yes, my lords, your lordship will recall this came up on Monday. Your lordship directed us to file the certified copy and carry out some correction, which we've done.
Acha.
But my lords, the cause list still for some reason shows defect. I'm not sure what's the reason after that. We checked with the registry also, but they were unable to.
Let us just check up the memo.
The preamble, my lords, didn't have the case number which we've put in.
That you have put in, yes.
Yes,
right.
and my lords, we've given a certified copy also now of the impugned order.
Certified copy has been filed in the department or before us?
My lords, department yesterday, my lords. We filed it yesterday with the department.
Yesterday, we'll just put it day after tomorrow. We'll seek another report from the revised
My
report.
lords, although, may I just say this, my lords, we'd
Yes.
also sought liberty from the previous bench to file without certified copy.
But you have now filed it. Now filed
Yes,
it.
my
So no
lords.
difficulty. No, Mr. Mitruka, liberty to file is something else, because before you take up the matter, you have to file. So now you have
I
filed
see.
also. Yes.
Yes, my lord, with file, my lords. This is a technical thing. If your lordship pleases, my lords, I am ready. I can make my submission. It's a very short matter, my lords.
What is the matter about? Yes.
So, my lords, the municipal corporation had initiated a 268 proceedings, which is to say that the building is in a dilapidated condition for demolition.
Yes.
And, my lords, this was the third round of litigation where, my lords, the learned single judge has interpreted the provision and, my lords, taken my submission. But ultimately, on the merits of the case, my lords, he said that, my lords, relying on some previous order, that order binds me and the corporation has acted in terms of the order, which is factually incorrect, I'll show. My lords, but before that, if I can give a brief overview of what has happened.
Yes.
Because I am a tenant in the building from 1985. Milords, in April 2024, the corporation, Milords, issued a notice under section 268. Your Lordship knows 268 is a provision which gives corporation the right to demolish a building which is in a ruinous condition.
Yes.
What they did, Milords, is that they only sent the notice to the landlord. I, being the tenant, I did not receive the notice. Milords,
As per the law, the occupants have to be given notice.
All interested parties, Milords, that's the phrase.
Right.
So, Milords, what had happened, Milords, I wrote to the corporation, they did not pay heed. Ultimately, I came before your Lordship. So,
Yes.
Milords, in the first round, your Lordships was pleased to direct that I am an interested party and I should be heard in this proceedings.
Yes.
And that matter was disposed.
Right.
After that, Milords, the corporation proceeded. I participated in the proceedings. Now, Milords, the scheme of 268, which I will show to your Lordship in a minute, is that first there has to be a determination that the
Have you
building
got a copy of the act?
Yes, Milords, my colleague will have, and Milords, it's there in the impugned order also.
Yes.
268.
Yes, Mr. please continue. Yes.
Yes. So,
carry
Milords,
on.
the scheme of the 268 is broadly speaking is this, that first, Milords, as step one, the corporation has to make a determination that the building is in a ruinous condition and that the building cannot be repaired at a reasonable cost. That's step one. After they make that determination, step two is to give a notice to all interested parties to say, if you are interested in undertaking the repairs. Step three, Milords, anyone can come forward to the corporation and say that, okay, I am giving an undertaking that I will carry out repairs as per your satisfaction. In that case, Milords, there is no question of demolition. If nobody furnishes an undertaking, then the corporation can go ahead and demolish the building.
What happened in your case?
I gave an undertaking, Milords. That undertaking was not considered. Ultimately, I came before your Lordship in the second round of writ petition. Your Lordship will kindly see that order because that order has some bearing. That starts at, Milords, page 312.
We'll look into, please refer to the internal pages. We have the memo with us. So just internal pages of there.
Milords, this I am showing, Milords, the order in the second round.
Oh, this is the third round.
This is the third round, Milords.
Very good. Which page? 328.
312, Milords. 312, the order starts.
312. Give us half a second.
Yes, Milords.
There are two sets of paginations in here.
Yes, Milords. The bold one, Milords, is for your Lordships. I'm sorry, Milords.
Very well.
It's in a large font, bold, Milords. 312.
Right.
Yes, Milords will come to 313 straight. Para 7.
Yes, para 7.
Yes. Admittedly, the petitioner is in occupation of a part of the subject property which has been directed to be demolished. The petitioner does have an interest in the subject property. The commissioner ought to have considered the undertaking filed by the petitioner for making the necessary repairs prior to passing the order of demolition. In view of the above, the corporation is directed to keep the order of demolition at abeyance till so-and-so or until a decision is taken by the commissioner in response to the undertaking to be filed by the petitioner.
So you had to file a fresh undertaking disclosing the nature of repairs they were to consider.
Milords, I filed an undertaking. Now, Milords, kindly see what the corporation does.
Which
Milords, that order which I challenged in this third round starts at page 344. And Milords, the relevant portion is at page 346.
Yes, please.
My lords, I have 346, which is the relevant portion.
Yes.
Yes. That in regard to consider the building to be fit for human habitation, the provision wide subsection 6 of section 268 of the West Bengal Municipal Corporation Act 2006 must be complied with. Also, the structural inspection report of the impaneled structure engineer needs to be based on the test results such as analysis test, WIS, pushover analysis in ETB, ABS or any other relevant engineering software, and the entire cost of performing the said test have to be borne by the petitioner. However, the expense incurred in the course of performing any test as stated above does not create any right or claim for SMC by the petitioner. The aforesaid inspection report of impaneled structure engineer will be checked and verified by the executive engineer of SMC, and based on this permission for undertaking repair construction would be deemed. Now, Milords, what the corporation does is, Milords, they put the cart before the horse. Milords, all this while the proceedings was at least under the assumption that the building may not be fit, and therefore the question of repair. After, Milords, this honorable court in the second round directed that my undertaking be considered, and I furnished my undertaking. They came back with a requirement of precondition to say that you first give me this test report, which is to assess the stability of the building, and after that we will consider your undertaking. Now, my lords, if I may directly bring your lordship's attention to 268.
Mr. Mitruka, there is one aspect of it. Even if
Yes,
you
Milord.
give a proposal for repair and
Yes, Milord.
give a proposal as to how you proceed to go about it, then also for that also structural engineer's report may be necessary. You are saying putting the cart before the horse, but this may be at the subsequent stage also, because to appreciate whether your repair work, suggested repair work would suffice, they may require a structural engineer's report also, that this is the condition, current condition, and your repairs, whether they would suffice. So for that, they were within their jurisdiction to ask for another report.
No, my lords, I bow down to that. My lords, I could have understood if after I carry out the repairs, they ask me to bring a stability report to show that the building is stable.
No, there's
Today,
a
my
click
lords,
here, Mr. Mitruka. There's a problem here because the previous learned judge, the second round,
Yes, my lords.
directed you to file a fresh undertaking.
Yes,
that
my lords.
fresh undertaking for making necessary repairs prior to passing the order of demolition, right? So
Please,
you
my
would
lords.
file a detailed undertaking disclosing the nature of repairs to be made by you.
Along
Now-
with the report of the engineer.
Yes. So for that purpose, engineer's report was necessary.
No, my lords, but that the scheme of 268 doesn't contemplate, and my lords, kindly see what the learned single judge holds. My lords, the problem is he interprets the order passed in the second round wrongly, my lords, in my humble submission. Your
let us
lordship will see in the stay application only page 114. The order starts at 103. My lords, it's a detailed order, and perhaps, my lords, the first case where the learned single judge took the pains to interpret the provision. We've not come across, my lords, any cases where this provision was interpreted, so interprets that. And ultimately, my lords, on the merits, my submission is he errs, my lords.
Let us see. Yes.
Yes. My lords, it starts at 103.
Hmm.
My lords will then see 108, he quotes the provision.
Right.
And my lords, after that, my lords, the learned single judge, my lord, took the pains to interpret, and my lords, I have no quarrel with the interpretation. In fact, he also says that these are 3-4 steps which requires to be taken. Your lordship will see the problem in page, sorry, my lords, it starts at 34, 113.
113, yes.
Yes, my lords. So turning on the merits, my lords, he starts, but I'll just take your lordship to 39, which is the main problematic portion on the next page. I am also unable to accept the petitioner's contention that the impugned orders are tainted by procedural impropriety. The commissioner has acted in accordance with the directions issued by this court from time to time. The petitioner did not challenge any of these orders. Consequently, sorry, my lords, your lordship has that?
Yes, please continue.
Yes. Consequently, when the commissioner acts in compliance with the directives of this court, it is not open to the petitioner to argue that the commissioner has circumvented the essential procedural steps outlined in section 268 of the Act of 2006. In fact, no substantial procedural lapses have been found in passing the impugned orders. Because what the learned single judge says is that he acted in compliance with the order. I have showed your lordship what the order says.
Mr. Mitruka, you have challenged this order whereby you are directed to produce a empaneled structural engineer's report.
Yes, my lords.
This does not, first of all, this is, you are not prejudiced at all. I mean, you should produce that report, and we don't find any irregularity either. This is an intra-court appeal. Why should you interfere? The court took a possible view.
No, my lords, may I
Yes,
just
we
say
also
this?
feel that yes, structural engineer's report, if the municipal corporation requires it, to put it along with your suggested repairs and to see whether those repairs will suffice, we think that this is a reasonable, one of the possible views at least taken by the learned judge.
Milords,
No
I bow
interference.
down. Milords, there are 2 or 3 things your lordship may consider. One,
Yes.
Milords, the very basis for the corporation to initiate a proceeding under 268 is
Yes.
that the building is not stable. Good, bad, corporation has taken a view.
True.
Milords, once that view is taken, then the next step comes to issue a notice calling for people if they want to carry out repairs. Now, Milords, if that view has already been taken and corporation has issued a notice, then where is the question of going back to the step 1, Milords? But what effectively the corporation is doing is, Milords, this indicates that they have not even taken a decision whether the building is stable or not stable. that first threshold they have to meet. Kindly see 268, my lords, for a minute.
Yes.
The provision will make it clear, my lords.
Yes.
That's there in the impugned order also, if that
No,
helps. your lordship.
there, Mr. Mitruka, here a prima facie view was taken, a preliminary opinion was formed by the corporation. Only after that they issued a notice.
Yes,
That
my lords.
preliminary opinion formation was not challenged by you at any point of time.
No, my lords, how it proceeded is essentially they did not give me a notice in the first round. So I've been, my lords, coming to your lordships.
We agree, but you were given that hearing fine subsequently, and you had an opportunity to challenge. I mean, you participated and submitted to the jurisdiction and did whatever.
No,
And
my
you have
lords,
quite fairly given a suggestion that I'll repair. So do
yes,
that repair, but we don't find any irregularity with this order, Mr.
no, my lords, the problem is this, my lords. Today, my lords, if they ask, I mean, I can understand a situation where, my lords, they consider my undertaking. They say that you carry out repairs, and before I confirm, I will want a stability report. Today, my lords, before even giving me an opportunity or before even, my lords, considering my undertaking, how can they put precondition when the provision doesn't require that, my lords?
Let us come to subsection 6 once.
Yes, my lords.
Because your argument is on that.
Yes, my lords. In determining for the purpose of this section whether a building is unfit for human habitation, regard shall be had to its condition in respect of the following matters. That is to say, my lords, repair, stability, everything is there.
So you say that this relates back to the first formation of the building.
Yes, my lords.
Because the language is one.
Yes, my
Subsection
lords.
1,
So
unfit.
the point, I'm so greatly obliged, my lords. So the point is simple, my lords. Either the corporation says that I am still at stage 1, I can understand. Or the corporation says that stage 1 is over, now I am at stage 3. Because my lords will see stage 1
now
has
they
another
merely
element.
you have already given us an undertaking.
Without prejudice,
disclosing the
I've given,
return.
my lords.
So
Without
they have
prejudice.
to just check up whether that is sufficient.
Please, my lords, please. And your lordship will see subsection 1 that has 2 elements, in fact.
Yes.
Which is very important, and my lords, which often is ignored. It says, my lords, if I can read with your permission.
Please.
Yeah. Where the commissioner, upon any information in its position, is satisfied that the building is unfit for human habitation, that's 1. And I will pause there. The second element is this. And is not capable at a reasonable expense of being rendered fit. So, my lords, there are 2 elements which needs to be satisfied. 1, that it's not fit. And number 2, that you cannot make it fit at a reasonable expense. Because, my lords, there's other provisions where the corporation has the power to directly direct the owners or interested parties that you make ABCD minor repairs.
But Mr. Mitruka, that stage cannot be reopened now because that is over now.
I bow down, my lords, but kindly see what the corporation is doing, my lords. They themselves don't know what they are doing, my lords. That's my case. They are going back to stage 1 now to say that you give me this so that I make a determination there.
Show us the portion of the section where it says about what the corporation will do after they get that undertaking.
Yes, my lord. So that is clear, my lord.
Yes.
Yes, my lord. My lord, will see subsection 2.
2, yes.
If any of the persons upon whom a notice has been served under subsection 1 appears in pursuance thereof before the commissioner and gives an undertaking that such person shall, within a period specified by the commissioner, execute such work of improvement in relation to the building as will, in the opinion of the commissioner, render the building fit for human habitation, or that the building shall not be used for human habitation until the commissioner, on being satisfied that it has been rendered fit for human habitation, cancels the undertaking. My lords, and then 3, if no such undertaking has referred.
That's a different question. So,
and my lords will see subsection 7 together with 2. There is a definition of what is work of improvement, and that practically includes everything under the sun. Subsection 7.
Yes. Structural alterations and all.
My lords, I also have a list of dates prepared in case that assists your lordship.
Need not. Mr. Mitruka, let us hear the other side. We have got your point.
Yes, my lords.
Yes, what do you say?
Yes, my lord.
You cannot go back to stage 1. That is his point.
Yes, deeply obliged, my lord. But according to section.
My lords, can I request my friend to use the mic? I'm so sorry.
Yes, please do that.
Yes.
I'm grateful.
According to section.
Your calves are still the same?
Yes.
Very good. Yes.
Yes. According to section 268 clause 1 and clause 2, it says that the commissioner has to be satisfied that the building is capable of being repaired. So, my lord, I would like to bring your lordship's kind attention to annexure P4, page number 131. Here an investigation was taken up. In the investigation report, the sub-assistant engineer has provided that it is a two-storied building whose repairing maintenance work has not been done for several years. At present, the top floor is lying vacant and the commercial activities are being rendered at the ground floor. The external part of the building, including the roof, is in a poor condition. Paling
Yes.
of concrete, worn out plasters and exposed rusted reinforcement of roof slab.
Agreed. But
My
only
lord.
after being satisfied, you have issued this notice and taken the undertaking now.
No, we after getting this
View.
we have requested all the occupiers of the building to provide an undertaking along with a engineer's report. That your lordship will get in the page number 132. This report has been provided by the landlord of the building. My lord, may I kindly go through
No, but
the report?
how could you ask for a report at a subsequent stage?
No, this is at the preliminary stage, not at the subsequent stage.
No, after you, along with the undertaking, you are asking for a structural engineer's report. Now, if you are not satisfied in the first place that it was unfit for human habitation, at that stage, you had to have a structural engineer's report to come to that conclusion. This insistence of yours on a structural engineer's report at this stage of undertaking itself vitiates your first formation of opinion.
No,
That
my
means you did not take that structural engineer's report at the first stage.
No, man.
Must have taken.
This information.
Why this insistence? This is dehors the statute.
My lord, may I, with your lordship's permission? This report, which is at page 131,
Yes.
this has been provided by our engineers.
Right.
That clearly shows that the building is in a deteriorating condition.
Yes, absolutely.
Which is not capable of human habitation.
So that's why they have
Hence-
given they'll give an undertaking, they'll say what repairs they want. And
Yes, along with that, as a precautionary measures, we had requested both the occupiers to provide a report from their respective engineers. There has been a difference of opinion in respect to both the engineers.
see, their engineer's report, is immaterial because this is not a landlord suit for eviction. It's against between you and the person who wants to repair. They have given an undertaking. You consider that undertaking, compare it with your own report.
My lord, now
it's your duty to do that. Why
My
should
lord.
they provide a structural?
My lord,
They will give their own version.
according to the undertaking which has been taken by my learned senior, by my learned friend's client, I would like to bring to that undertaking. My
No,
lord.
you decide on that undertaking. Your job is
My
under
lord,
the
we have
law.
decided on that undertaking.
You have said that it's not sufficient.
Yes, we have stated that it is not sufficient.
That is after this impugn order. Your impugn order. Acha, you have said that it is not sufficient.
Yeah, and after that we have.
That is after 12th of November 2024.
Yes, my lord.
Milord, let him show that document. It's not there, Milord. I'm sorry to interrupt, but let him show that document to your lordship.
No, what have you held? 347, it's there.
My lord, kindly come to page number 347, which
Yes.
is dated 28th of December 2024.
Yes.
Here it says that reply to your letter dated 24th December 2024. This is sent to my friend's client by the commissioner, wherein it has been stated with reference to your, may I read, my lord?
No, your only ground is that they have not produced that report.
Yes.
Only on that ground. So you
Yes.
insist on that order. You have not said that their report. You have already must have taken a structural engineer's report before you form the opinion.
We have taken a report from the assistant engineer. That is on the very first page.
So you decide on the undertaking now.
Yes, my lord.
Why should they?
As because
See, they will provide their own. They'll appoint their engineer from your panel, and they may influence the engineer.
my
also.
lord, now, my lord,
You have your independent opinion by appointing your
my
engineer.
lord, my lord, kindly come to
Why should you insist on them producing a?
my lord, with your lordship's permission, my lord, kindly come to section 268, clause 6,
Yes.
subclause B, that speaks about the stability. Here, my lord, your lordship will kindly appreciate that Siliguri is a place which is situated on a high seismic zone.
True.
So, as a result of which, the livelihood of the individuals who are residing in the ground floor of the building is the primary concern of the corporation.
100%, no doubt on
So
that.
as a result of which the corporation has to be 100% sure to the extent that yes, the building even after repair, because it's a very old building, which is in a very dilapidated condition. The report by the engineers has categorically stated that it is not in a condition to be happy human residence. As a result of which, my lord, kindly appreciate to the extent that as
So you want a further report from him for what purpose?
in order to show that yes, even after repair, say for example,
So you want a post-repair,
not post repair,
pre-repair?
pre-repair.
So
that even
pre-repair, you
after
have already formed your opinion on your structural engineer's report. Otherwise, you could not have declared it to be unfit for human habitation.
Well, I did not get it.
You could not have given a notice under subsection 1 if you are not satisfied that it is unfit for human habitation. You must have been satisfied
Yes,
on the basis of some structural engineer's report. You have taken that opinion.
Yes,
You are within your jurisdiction to do that. After the last order of this court, they are to give an undertaking now disclosing the nature of the repair. They have have disclosed that. If they disclose that, your only job is to assess whether that would suffice and take a decision on it. Stability, you are already dissatisfied on stability. You already have your report. Otherwise, you could not have taken the first decision, the first opinion.
Suffice whether that repair will make the house.
So you want a comparison,
Yes,
a structural engineer's report and their proposal to compare whether this would suffice.
That, my
Very
lord.
well.
And my lord, one more, my lord, with your kind.
Yes,
permission,
yes.
Yesterday, I was doing some research, my lord, regarding because I was not aware about what is this pushover analysis.
What is that?
My lord,
Sorry,
pushover.
Because I am not able to hear my learned friend. I'm so sorry,
Use
my
the
lord.
mic. Use the mic.
Sorry, my lord.
Pushover analysis case is actually.
Come a bit closer. Take the microphone closer to you.
My lord.
Mr. Dhod will help you in doing that.
Pushover analysis test is actually done in areas where there is, which is, prone to earthquakes, my lord.
Right.
Like Shilikuri being in a high seismic zone, my lord, the commissioner must have played in his mind that the life of the inhabitants is of the prime
No,
concern.
that is obvious. That is all our concern.
Result of which he wanted this report.
So you want a report along with that proposal so that you can verify whether that repair work would suffice.
Yes, regarding the stability of the building.
Got you. Let us hear him. Yes, reply, Mr.
Yes,
Mitru.
your lordships will kindly see subsection 7 of 268.
Yes, we are there.
I want to emphasize on what kind of repairs I can carry out in the building to make it fit. Your lordship will see B says structural alterations, and my lords will see the last one, I.
Yes.
Any other work, including the demolition of any building or any part thereof, which in the opinion of the commissioner is necessary for executing any of the works A to H. Because the point is simple. The scheme of the act is such that I can do anything which is required to ensure that the building is fit and the building must be preserved. Factually, my lords, the situation is this. I am a tenant at the ground floor. First floor and second floor, my lords, are in a dilapidated condition. I have no doubt. My lords, there are no residents or occupants. And my lords, my case throughout has been that the landlord is trying to indirectly evict me. And therefore, my lords, I had to come. Landlord, in fact, his stated position and affidavit is that the building must be demolished so that I can be thrown out. So, my lords, in my undertaking, what I have said is that I will demolish 1 and 2. And ultimately, what remains is only the ground floor where, my lords, I am operating a kirana shop. So, my lords, that's the factual position to give your lordship perspective. Number 2, my lords, my learned friend has relied on that SMC report of March 2024. My lords, there are problems in that report also. Your lordship may kindly give me a minute, my lords, in analyzing that report at 270.
No, Mr. Mitruka, we don't find you being prejudiced in any manner if you give another structural engineer's report, because that will help them come to a decision.
My lords, may I say this?
Yes.
Sorry, my lords, may I say
prejudice factor is not in
no,
your
my lords, there could be only two situations. One,
yes,
that the report says building is unstable, or the report says building is stable. In either of the situations,
no, the nature of the problem with the building, Mr. Mitruka, that will come out, because the stability is a very vague term. Suppose specifications are given, technical specifications, that this are the instabilities in the building. Now, and your repair does not address those issues. The current position, if that is ascertained that this is the nature of the instability and this is the work required to repair that, that will provide a platform for them to compare with your suggestion, your undertaking, whether that would suffice. So they are just simply asking for a stability report, a pushover report, on a pushover analysis. Do
Milord,
that. Let us see.
I have no problem. And
Even
Milord,
if you
this-
demolish, the upper two floors, then Mr. Mitroga, now you are trying to evict your landlord. That's all right with us.
No,
We don't have any qualms whatsoever between whatever is happening between your landlord and you. But the difficulty is they have to be satisfied that yes, first and
Milord,
second, the second and third floor can be demolished or the upper floors can be
Milord,
demolished.
I have in fact a report. Your Lordship will see
Give
page
that-
321. I'm
Give-
sorry,
give
Milord,
that
just one last
Take,
document.
take out a report and we don't find the
Milord,
prejudice factor in your favor.
May I just say this then? Milord, let
Yes.
them appoint, Milord, because I have reached out to some
You
engineers.
pay, they'll appoint. You pay, they'll appoint.
Milord, it's over 2 lakh rupees. This is what, Milord, I can spend on repairs, Milord. This pushover, etc. What they are saying is a very expensive test. And Milord, this of course is not in line with the scheme. Now it's a huge cost burden over and above the repair cost because that also I have to pay from my pocket. Milord, I'm being absolutely candid to your Lordship, and that is the reason we are coming here. And Milord, when I gave my undertaking, it's not that I did it out of thin air. I got to an engineer's report. That report, Milord, is at page 321. But obviously, Milord, corporation will not believe my report. They will say that he is influenced, etc., etc. So I didn't even show your Lordship that report, which was the basis for my undertaking.
One question.
My lord.
Why shouldn't you appoint that commissioner? There is no burden under section 268 on him.
To appoint, but
Why shouldn't you bear the costs? Let us be more specific. Why shouldn't the corporation itself? Because you are trying to ascertain the veracity of their repair undertaking. Now it's your incumbent duty to do that. I mean, why should they pay for the repair as well as do this? He's a tenant or an occupant. Yes, he might have a duty if he wants to continue there, he will undertake the repairs. Law does not cast any burden on him to produce any such document because the only thing where we see that you definitely have a right to have a stability report or whatever, but you have to do that in your own cost because at the in its inception for formation of the opinion you appointed your own engineer. Do that now also. Why cast the burden on them just because they want to repair and stay on there living there? If you want to be satisfied, see, there are two. Let us finish and then you'll answer. There are two components to your examination now at this present stage. One, whether their undertaking would suffice, and for that you require a basis of comparing that with what is actually required. So that basis has to come from you. It's your liability to now ascertain whether that report is sufficient, that repair work is sufficient. So why don't you appoint an engineer from your pocket and do that?
my lord, may I?
Yes.
My lord, at the very instance, my lord, let us put the case in a very straightjacket formula. At the very instance, both the landlord and when the tenant came into the picture and the tenant were requested to provide a report to that extent, my lord. There was difference what the commission.
That is why again you are asking for a report from them.
No. There was a difference in
Yes.
between what the engineer A stated and what the engineer B
Understood.
stated.
Understood. Proceed further.
When there was a difference in the opinion, my lord.
What should you do ideally when there is a difference of opinion between the two?
And as a result of which,
What should you do ideally?
we inquired from our engineers.
Yes.
From our engineers that what is the best possible way to detect whether the building is competent of being repaired or not.
Yes.
And the engineer stated that the latest technology is the pushover analysis test.
You push over your own engineer and get the report. Why should that duty be cast on them? There is no, under the statute, there is no compulsion on them to do. Because this is under 268(2) now. Now that says that they will just execute the work of improvement in relation and in your opinion of your commissioner, render the building fit for. So your opinion has to be formed by you by appointing your own engineer. Pushover or otherwise, don't be a pushover.
No, my lord, no, my lord.
No, you appoint your own.
No, in that event, my lord.
Then nobody will come up and repair. Every building will be, you will have a golden day. You will demolish all buildings in Siliguri because it's on a seismic zone, and the day after a supermarket will be coming up.
No.
Sorry, no.
Said we demolished a supermarket.
Oh, must be something else coming up. The owner will change.
No, my lord.
We know what happens at the ground level.
Honestly, pray for some time in order to inquire from my law officers that
You, that hope that day does not come when your law officers advise you, and your law officers' advice is binding on the court. Hope that does not
no,
that day does not ever come. Your law officers will abide by what we say, not the reverse.
Let, my lord, one suggestion from the corporation, my lord. Let the owner of the property as well as the tenant.
Owner is Mr. Das is obviously.
Yes.
Let him file an eviction suit against himself now because
What I quote. He is not the tenant.
that will take care.
And
Let him
both of
repair a
them-
building and get a license eviction. It will be easier for you. Your building will be repaired, you will get a license eviction. 2G will come. So it's
but
easier
in
for you.
that event, my lord, let both the owner as well as the
We
occupier.
thought about that, but there is no liability under the statute. Why? Why should either of them do that? You have to do that. We'll reinterpret this too. The present challenge has been preferred against the order of a learned single judge, whereby the appellant's challenge against a decision taken by the Commissioner of the Siliguri Municipal Corporation directing the appellant stroke occupant of the concerned building, to furnish a structural inspection report on a pushover analysis from an empaneled engineer. Full stop, next para. Learned counsel for the appellant argues that within the contemplation of 268 of the West Bengal Municipal Corporation Act 2006, which is the relevant provision in the present case, in the event the commissioner, upon any information in its possession, is satisfied that any building is within double inverted unfit for human habitation, double inverted close, and is not capable at a reasonable expense of being rendered fit, it shall serve upon the owner of the building and upon any other person having an interest in the building, whether as lessee, mortgagee, or otherwise, a notice to show cause within such time as may be specified in the notice as to why an order of demolition of the building should not be made. Full stop. In the present case, initially such notice was issued according to the appellant, only on the landlord of the building. Full stop. The appellant claims to be a tenant of the building, which is disputed by the landlord, who is also appearing through counsel before us. Full stop. Next para. Be that as it may, it is not in doubt that the appellant is an occupant of the ground floor of the building. Full stop. Next para. Learned counsel for the appellant contends that since no notice under section 268 within bracket 1 was given at the initial stage to the appellant stroke occupier, the appellant was compelled to move this court and obtain an order whereby such notice was directed to be issued. Full stop. Thereafter, an undertaking was initially filed by the appellant, which was not accepted by the respondent corporation. Full stop. Next para. Subsequently, pursuant to another order of the court, directing the appellant to furnish an undertaking by disclosing the exact nature of repairs proposed to be undertaken by the appellant, the appellant did file such undertaking, upon which the impugned order of the Commissioner of the Siliguri Municipal Corporation dated November 12, 2024 was passed. Full stop. Next para. Learned counsel for the appellant argues that the formation of opinion as to whether a building is unfit for human habitation, as contemplated in section 268 within bracket 1 of the 2006 Act, has to be done in the context of subsection 6 of the said section, which provides that in determining for the purpose of the section, whether a building is unfit for human habitation, regard shall be had to its condition in respect of the matters as specified therein, including stability. Full stop. Thus, it is argued that the very insistence of the corporation on a structural engineer's report itself shows that the initial formation of opinion regarding the building being unfit for human habitation was tainted. Full stop. Before formation of the opinion, the corporation had to have a similar report, and comma as such comma the insistence for a further report at the cost of the appellant is superfluous. Full stop. Next para. Learned counsel submits that the learned single judge proceeded to interpret the various provisions of the section, but uh, in an erroneous manner, comma, arrived at the finding that there was no procedural impropriety on such insistence of the corporation for the engineer's report. Full stop. Next para. Learned counsel appearing for the Shiliguri Municipal Corporation submits that it is well within the jurisdiction of the commissioner of the municipal corporation to seek a fresh engineer's report before ascertaining and for the purpose of ascertaining as to whether the suggested repairs of the appellant would suffice to restore the building to a habitable condition. Full stop. Next para. Learned counsel further points out that in view of there being a dispute regarding the property between the landlord and between the owner and the occupant, that is the appellant, comma, two contradictory reports came from the said two persons. Full stop. Next para. In view of such contradiction, comma, it is all the more necessary for a further report to be obtained. Full stop. Next para. Learned counsel for the corporation submits that it is the incumbent duty of the occupant, comma, who seeks to file an undertaking for taking up the repair work, comma, to furnish an engineer's report as well in order to permit the corporation to ascertain the veracity of such repair work. Full stop. Next para. Upon learned counsel for the landlord supports in principle the contentions of the corporation and denies that the appellant is a tenant in respect of the property. Full stop. Be that as it may, comma, the juror relationship between the owner of the property and the appellant is not the subject matter of the present consideration. Full stop. We are conscious that the court, comma, sitting in an inter-court appeal is more cautious than in other appeals, and we have to consider whether a plausible view was taken by the learned single judge. Full stop. Next para. On a careful perusal of the provisions of section 268 of the 2006 Act, comma, even going by the interpretation lent to the same by the learned single judge, comma, we find that the duty to ascertain whether a building is unfit for human habitation is cast upon the corporation under section 268 within bracket 1 of the 2006 Act. Full stop. Subsection 2 thereof, comma, which is applicable in the present case, comma, provides that if any of the persons upon whom a notice has been served under subsection 1 appears before the commissioner and gives an undertaking that such person shall, within a period specified by the commissioner, comma, execute such work of improvement double inverted মধ্যে in relation to the building as will, comma, italics say, in the opinion of the commissioner, italics say, শেষ, render the building fit for human habitation, or that the building shall not be used for human habitation until the commissioner, on being satisfied that it has been rendered fit for human habitation, comma, cancels the undertaking, comma, the commissioner shall not make an order of demolition of the building. So next para. Thus, comma, the charter of the commissioner of the corporation is, comma, upon an undertaking being filed, comma, to form an opinion of its own as to whether the work of improvement suggested by the person giving the undertaking would render the building fit for human habitation, or that it shall not be used for human habit, or that থেকে কেটে দিন, full stop. In the event the commissioner is not satisfied on such count, comma, the commissioner has the liberty to cancel the undertaking on such grounds as it deems proper. Full stop. Next para. Subsection 7 of section 268 provides a rough definition of double inverted the work of improvement in the manner that for the purpose of the section, comma, such expression would, in relation to a building, include any one or more of the following works as specified therein. Full stop. Next para. Thus, the limited duty cast on the person giving the undertaking under section 268 is to file an undertaking disclosing the nature of the repairs. Full stop. However, no such duty is cast on the said person. Also, to provide or furnish an engineer's report to assist the commissioner in coming to appropriate findings on the undertaking. Full stop. Such duty is cast squarely on the commissioner under subsection 2 of section 268, since the commissioner, upon getting the undertaking, has to ascertain whether the work of improvement suggested would render the building fit for human habitation. Full stop. Next para. Since it is the incumbent duty of the commissioner to ascertain whether such work of improvement would suffice, it is obviously upon the commissioner to take appropriate information and or seek a report from the empaneled engineer of the corporation itself for the purpose of deciding on the undertaking. Full stop. The reversal of such burden, being cast on the person giving the undertaking is not contemplated in law. Full stop. Next para. As such, although we agree with the interpretations lent to the section by the learned single judge, with utmost respect, the procedural infirmity in the present case pertains, which pertains to the commissioner insisting upon the structural engineer's report being furnished at the cost of the petitioner, without the law casting any such duty on the person giving the undertaking, is perverse and as such requires to be interfered with. Full stop. Accordingly, MAT 52 of 2025 is allowed, thereby setting aside the impugned order dated May 5, 2025, passed in WPA 324 of 2025, and and consequentially setting aside the order dated November 12, 2024, passed by the Commissioner, Siliguri Municipal Corporation, with reference to Office Memo number 128 SMC N capital B small LDG building /2024-2025 dated July 3, 2024. Full stop. Next para. The Commissioner of the Siliguri Municipal Corporation shall now proceed to decide on the undertaking furnished by the appellant under section 268 within bracket 2 of the West Bengal Municipal Corporation Act 2006 by whatever mode deemed fit proper by the commissioner. First of, for such purpose, it will be open to the commissioner to appoint an empaneled engineer of the corporation to ascertain the stability of the building or the stability or the condition of the building which it would attain upon the suggested repair work being done, by way of a pushover analysis or otherwise. Full stop. It is expected that such exercise shall be undertaken at the earliest by the commissioner, preferably within what will be a reasonable time. This engineer thing.
Within a period of 8 weeks.
8 weeks should be too long because both of them are suffering.
1 month.
1 month.
4 weeks.
Preferably within 4 weeks from date.
One more indulgence before your lordship. Let both the owner of the property and the occupier of the property bring a detailed report of what sort of repairs are required.
They file their undertaking, either you reject it or accept it.
Man,
If you are not satisfied, reject it.
no, detailed report regarding what sort of a repairs are required.
That they have filed.
No,
We
haven't
filed that
stated-
already.
They haven't stated what repairs are required.
Whatever they have filed, you decide on that.
Bye.
That is the law. There will be no rise to costs.
I am deeply obliged, my lords.
Thank you, Mr. Mitrukar.
Grateful, my lords.
Can আছে pending, na?
Yes, my
Can
lords.
one of
Can.
2025 and one of 2025 is consequentially disposed of.
Grateful.
Thank you.
Deeply obliged, my lord.
Thank you so much. Yes. Mr. Das threatened us yesterday to be personally present in court to move a matter, and he has kept his word. Yes. Who is that?
I'm for the petition.
Right.
For this.
Unless it's a short matter, we won't take up the
Very
matter,
short matter.
then move it.
This
Yes.
is a GST.
Because we
matter.
want to, GST cannot be very short for
It's
us.
a Very short issue. And I have.
Apart from the expression GST, nothing is short about GST.
My point.
Then it's short. Yes.
Good points I'm making, Milods. Milods, I am.
Limitation also 4 points.
No, Milods, my challenge was, Milods, I'll.
No,
this-
we shall,
we
should
have-
we confine ourselves to the limitation question only?
My challenge here was that at the adjudication stage, I was denied a personal hearing. That aspect was not considered by the single judge, Milods. That is my main contention. The delay part will come later on, Milods. I am impugned, Milods, I have, in this case, I have impugned the judgment passed in 11th June 2025. My lords will take para 5 and 6 of the judgment. The only issue that was decided was whether any sufficient cause was shown in condoning the delay application.
What was this about? Under which provision?
My lords, this is under the GST
GST,
Act.
yes, I mean, you
my,
can take your seat. I will.
An adjudication order was passed against me.
Yes.
I filed my appeal belatedly, after which I approached the writ court.
Belatedly means that 30 plus 1,
After
3 plus 1.
Yes, after that,
Again that.
I had taken the two grounds. One was a medical grounds of both the partners. Another ground was that the final order was uploaded in View Additional Notices portal. Now, this View Additional Notices portal, my lords, is a pan-India issue, which the assessees across India are facing. We have prepared compilation where we
What is the irregularity in that? View access?
I'll tell you, my lords, in the GST portal, there is a tab called User Services. Under that tab, there are 15 options. I will place that. Apart in those 15 options, my lords, there are two options. One is View Additional Notices and Orders. Another tab is View Notices and Orders. Now, my contention was that since they had made some systemic changes in the portal, all the orders and adjudication orders were uploaded at the View Additional Notices portal, rather than uploading it at View Notices.
Without the additional.
Yes. So this aspect has been taken cognizance by several high courts.
No,
And I should
you
place-
checked the minus additional
Yes,
tab.
I checked the View Additional Notices portal.
where they should have put in.
View Notices portal, I'm sorry.
Without additional. You saw without additional? They put it in additional.
Additional.
You said should have been put in the without
View
additional.
notices,
But why don't you check up both? It's just a question of checking up both.
That is my.
Isn't that a hyper technical thing?
But this is a
You are the assessee. Yes, but you won't look into, you won't look into, if you check up an order in respect of writ petition, don't you look up all the orders? I
Yes,
mean,
but what happens in
it's your negligence.
laws, income tax or any other law, there what happens whenever any orders are being uploaded in the portal, the assessees are being intimated through online or through.
Suppose there was no intimation for some technical reason,
This
but
is-
it's your
Pan-India.
your
This is
duty.
my-
Pan India maybe, but the problem is not such a problem. I mean, view additional and view orders. You have to check up both only.
Their portal design, what the problem is. My lords will understand what I'm trying to indicate.
No, you cannot access both.
I can access both, my
Then-
lords, but then it went out with because it is a less.
So for that, what did you miss out on?
I came to know about the adjudication order only in the month of March 2020.
That was the reason for the delay.
One of the reasons for delay. Another reason was medical grounds, which they have taken note of.
Very well. So
This
that is your
one-
ground.
one aspect. This is one
Personal hearing, how does?
aspect is, my lords, in the show cause notice, the date for personal hearing was fixed prior to the date of filing my reply. This, my lords, is a meaningless opportunity.
Please repeat that.
The date of personal hearing, my lords, was kept prior to the date of filing my reply.
Oh, reply. Hearing has to be on the reply. Okay.
Date of personal.
Show us that first.
Yes, my lords, yes.
That is more interesting. That should interest Mr. Rahman also, your friend.
Take page number 60. 60, relevant pages 61 of my CAN application.
Yes.
My lords, the date of personal hearing
It's
is.
a very loud notice.
Yes, my lord.
Notice written all over. I mean, with in bold letter. and-
Date of reply is 10th June and date of personal is 3 June, my lord.
Yes, right.
Then I come to page number 67, which is the reply I filed And the operative part is, my lords, at page number 70.
You file it within
I've within
10th.
the timeline on the 10th. Kindly see, my lords, last paragraph. Therefore, kindly close the proceeding. You are requested not to pass any adverse order without before giving opportunity of personal hearing.
Obviously, yes.
Now, my lords, will take page number 82. How they deal with this request.
This is already over or what?
Yes, my lords. They say that I have already provided you one. 82.
82 years.
The RP in his reply dated.
Isn't the hearing on the reply? Has
Yes,
to
but
be.
this-
Any hearing is,
Division-
need not be held by any court. I mean, unless you,
This is a statutory mandate.
what will be the hearing on? Unless you give the reply,
Yes.
you are heard first, then give the reply. They would not be saying that also.
Page number 82, minutes, first two paragraphs.
Yes.
They have dismissed this because they say that I've already provided you one.
And they reiterate the date also here.
On this point, my lords, there is.
And this assessment, I mean, this was at the first instance.
This was at the first.
First instance, you preferred an appeal against this medical ground and technical difficulty ground. Medical ground, several high courts have held that it's a good ground.
Yes.
226. We have seen,
And
although we don't agree with that view on principle, because, but if so many high courts have held, we want to waste time.
here my delay was not dismissed on the grounds that I don't have any power to condone delay. The appellate authority acknowledged that SK Chakrabarti judgment, which my lords had seen yesterday, acknowledged them and after that said that no sufficient cause was shown.
You have given everything except SK Chakraborty.
SK Chakrabarti is there, my lords. That is not disputed by them. They have said no sufficient cause shown, excepting SK Chakrabarti.
SK Chakraborty is under stay, but obviously you have the obvious
Yes,
reply
my
to that,
lords.
which
Yes.
they will agree also. On law, they will agree.
And my lords, on the point that where there is violation of natural justice at the adjudication
Those are the
stage,
two mitigating factors.
yes,
We have
Writ-
been taught yesterday.
writ court can interfere, my lords. I am relying on a constitutional bench judge. In 1957, SCC,
What was the opinion of the learned single judge?
single judge, my lords, only considered learned single
Yes.
judge, my lords, only at paragraph number 5, my lords, considered the delay aspect. The violation of natural justice aspect was not considered, although it was
Did
argued.
you argue it?
Yes, my lords, as well as pleaded in my petition.
Pleaded,
was-
we plead so many things
No,
you are not
but
arguing and we don't know.
This year, she'll be fair. Miss Reema Sarkar, I had argued.
No, both of them are fair. Yes.
My lords, paragraph number 12.
Delay aspect was, what was the opinion of the court?
Delay, my lords, para 7 of the impugned judgment. Just one paragraph I'll place from this, although this does not relate to tax, para 11, my lords, of the majority opinion. Input. May I read?
Yes, yes.
On
I
the
need not read
authority-
the thing. What has been held? Jurisdiction.
If an inferior court or a tribunal of the first instance acts wholly without jurisdiction or patently excess of jurisdiction or manifestly conducts the proceeding. with-
Natural justice, yes. Very well.
And my lords, on additional notices point also,
Yes.
I have prepared a compilation.
What does that say? Those judgments say? What is the proposition laid down?
It says that this is not a good service. Go to there. Unko bhi de. I have indicated the paragraphs as well for lordship's perusal. Ek unko bhi de copy. And my lords, my submissions I have made a notes on written notes on my submission.
Wait, let us see whether we need it at all.
ये बता दो। मैं ये नहीं ऊपर दूसरा कॉपी।
Very well. We have seen.
And my lords, written notes I have prepared on my major 4 arguments which I have said.
Why 4? Let us
I
just
will tell you, my lords.
Ch-
One is first is
give us half a second. Give us half a second.
Yeah.
One is medical. So delay. Let us subdivide it. Delay
first
first.
is, my lords, violation of section 75(4), which is personal hearing, denial of personal hearing. Second is, my lords, defective service, violating section 169 as has been held by different high courts. Thirdly, my lords, my
Where is this section?
169, which provides for service. Thirdly, my lords, my alternate prayer, if my delay to be condoned, that is on the alternative what I am praying for.
Medical and this technical error.
These are the three major components. Fourthly, I have.
So section 169 corresponds with your delay ground also.
Yeah. But it seems that the notices have to be uploaded in the common portal. So that aspect was not considered, which place in the common portal it has to be uploaded.
So that was one of the grounds of delay also.
Yes, it was.
So why 4? What is the fourth ground?
Fourth point, my lords, I have said that this is a denial of an effective remedy because, my lords, the scheme of the act under
Which
the
is a denial of effective remedy?
by if they do not hear me on merits, my lords, what happens here is I have my.
So that pertains to your personal hearing point. That's a corollary of that.
Yes.
Obviously, right of hearing is given in the statute. Yes.
But takes up the impugned order. Everything is explained. The impugned order is detailed, well reasoned. Takes up the impugned order. Paragraph number 1, subparagraph number 2, if I may.
Yes.
It starts with the appellate order dated 23. So the appellate order was passed on 23rd of April 2025 by the appellate authority.
Right.
This was the respondent number 3, who is the appellate authority and refused to condone the delay in filing the appeal.
Yes.
The delay portion that has been explained in the middle of that paragraph,
Right.
if I may read out the relevant part.
Yes.
I think 1, 2, 3, 4, 5, 6, 10th line onwards.
Right.
However, the petitioner failed to submit any reply within the stipulated.
Take your seat. You take your seat.
Specified stipulated period. Subsequently, show cause notice dated 10/5/2024 was issued, directing the petitioner to explain why tax, interest, and penalty could not be imposed. In response to the aforesaid show cause notice, the petitioner submitted a detailed written reply dated 10/6/2024. After considering the reply, the respondent authority proceeded to pass the assessment order dated 12th of August.
First flaw here. First flaw here. No hearing was given to them. First flaw in the logic.
The personal hearing date was stated in the show cause notice. They chose not to appear. That reason has been given.
Third of prior to the.
They could have appeared for the personal hearing. They chose not to appear.
How could they appear in the personal hearing without filing a reply?
But they could have appeared in the personal hearing. They could have submitted the document subsequent thereto. They could have.
Isn't the hearing on the reply? Then what is the purpose of reply?
The purpose of the reply is to submit the statements in writing.
Right. So yeah, I submit my. That's not a written notes of argument sort of thing. It's a written statement sort of thing.
Sort of thing which is given to the
The hearing is given on that only.
which is given to the
Hearing is given on the reply itself. Let us see the relevant provision.
made at the personal hearing that can be submitted in the form of writing.
Let us come to 75(4). 75(4), yes.
73(9) also, my lords, first, under which this order has been passed. For relevant provision. My lords, I have taken out this relevant provision.
Under the relevant hearing clause is under 75(4).
These are the relevant sections which are.
We'll keep it. We'll keep it. Yeah, very. Thank you.
73(9), my lords, first.
Hearing is 75(4).
है उठा dashboard.
No, we need to look at 75 as a whole.
75. Let's.
75 relates to
Relevant
the general
right, sorry.
relating to determination of tax.
GST Act যেটা কালকে
Yes.
ওটা তো আমার কাছে চলে গেছে
वो खोल के दे।
This is a West Bengal Act.
मतलब same.
Exactly same.
Same
না আপনি নিন
Sections are also.
sections are. Okay, fine.
আমরা ঘুরে আসি একটু প্রভিশনটা দেখি We'll come back in 10 minutes and take a break. এই বইটাও সঙ্গে নিয়ে যাও বইটাও নিয়ে চলো Opportunity of hearing.
Yes.
So your argument is that you give that date on 3rd of September. They could have come on that date and
Yes. Now, the statute says that opportunity of personal hearing has to be given. That has been given.
75-4 as
The choice of the SSC, he chose not to appear on that personal hearing date.
very well.
And the judgments which have been cited, my lord, in the compilation,
Yes.
in most of the judgments I find where the date of personal hearing was not even mentioned in the notice concerned. Show cause notice. It was stated as NA.
All these cases.
Most of the cases I find. In the first one, my lord.
In which one it was there?
Yes, my lord.
In all the cases it is there.
No.
I have specified the paras also.
Yes,
I've specified
We'll look into the
paras.
paras. We'll look into the
My
paras.
lords may.
There are 3, 4, and 5 in the first judgment, my lord.
And thank you very much for this extremely good compilation because they've given the head notes also the point on which there is a site, which
Short list of dates are.
very well.
But
Thanks.
in the first judgment that they have stated,
Yes.
the compilation where, let us take up paragraph number 3.
This is the personal hearing point. Yes.
Personal hearing.
Personal. Date of personal hearing is prior to which the reply, this is also the same, to which the reply show cause notice has to be submitted. This is known as, and this practice has to be discontinued. Date of reply to the show cause notice has to be definitely prior to the date of personal hearing. This is an observation made on an office memo which was issued
Yes.
to all by the additional commissioner concerned. This is not the observation of the court itself.
Point
And
3
the
is
observation of the
important.
court is that, well, in this case, the date of furnishing currently takes up the relevant portion. Date of furnishing the reply was not actually given. That is the problem. Well, takes up the relevant para. That is paragraph number 5.
No, this
In
was a
order to
memo
take
issued by the additional commissioner himself.
Yes.
So your additional commissioner.
That office memo.
But
wasn't
that
in
binds
office-
you,
that-
the date of reply to the show cause.
different states. Pertaining to a different, not the state of West Bengal, pertaining to a different state. Now,
But on the
as
same
it is-
statute provisions are the same.
Yes, the statute does not say that the personal hearing has to be given prior to the date of filing of the reply. That the statute does not.
If
say.
there is a right given to give a file a reply, then it
Yes.
has to be before the date.
But
And that is what
that-
the UP additional commissioner said also.
even if that is there,
But
the judgment.
We'll ask in reply, your learned friend, whether, I mean, the statute does not provide for any reply
Yes,
separately.
yes. And
So you be prepared for that question, we'll ask you that.
Yes.
When in reply, we'll do.
yes,
You
but-
take your seat, need not keep standing, yes.
No.
So
And but-
yes, so you say this is a different state, that
Yes.
was an internal memo,
That-
that is not the law as such.
And the statute does not say so. And the thing that remains that it stated that it was not uploaded, that is entirely wrong. With respect to that, I come to the next part of the order concerned, internal page number 2 of the impugned order.
Yes,
If I may read the relevant part. After considering the reply, the respondent authority proceeded to pass the assessment order dated 12th of August 2024, determining a final demand of 17,79,000 something. This order was uploaded in the WBGST portal. So order was there immediately. Order was uploaded immediately. The petitioner thereafter filed a belated appeal on 2nd of April 2025.
then let us be clear on this.
Yes.
There are different portals for different states, right?
There is a single portal. GST portal is one.
One.
Yes.
If that be so, but in that portal, you go to your state and find out.
Yes, GST number has to be put.
But if it's a pan-India
Number is associated with the state concern.
state concern, very well. If there's a pan-India problem which has been reflected in other judgments which your learned friend cited,
But that is the
why shouldn't we?
personal hearing? That is with.
No, on
No, on this also. He has given us bunch of judgments on this.
Across the country.
Here it is uploaded in the portal. In
Same.
some cases, it has not been uploaded in the portal.
No,
And
Suppose if you take the first one,
Yes.
on the show cause notice being uploaded, Lord Vishnu. So Lord Vishnu has come to his rescue.
Well,
18 to 25, if you go there and if you come to para 20, which caught our eyes at the first glance,
first judgment, para 20.
para 20. Now second sentence says it was after Supra, it was found that the show cause notice was uploaded on the portal in the category additional notices which were not easily accessible, hence skipped the attention of the petitioner. Now,
It is on the same page. That is the thing. The page is the same. On the same page, it is available side by side.
which are not easily accessible, it says.
That at that moment of time might have been, but now the portal has been updated. But that explanation is already been given.
Can you access from your phone the portal and show us?
My lords, I have discussed supplementary affidavit.
But have you given a copy to them?
Yes, I have served them. Yesterday I served them, I'll serve them again.
Yesterday they'll never get it.
बीमा दी के दिए थे। नहीं और एक देख कैसा check दो। मैंने अच्छे।
So now can any of you just access that portal and show us that additional tab?
My lords, now they have rectified. Now they have rectified because they faced this all over India. This has been the law from the High Court. My lords, kindly take page 6 of my supplementary affidavit.
A lot of corrections has been made in the.
Yes, of course. But
When
this is a
made it
old
on?
case, my lords.
This is the.
Kindly see,
There
take
were
page
problems
6,
initially.
page 6 of my supplementary affidavit, my lords. Page 6. This is the user services where my lords will see right hand side, the third column is view notices and order, third point. And fifth last is view additional notices. My lords, how do I identify from where this is view additional or view? This is a practical aspect, my lords. which
No, but
has
you
been-
won't look into both. View notices
Maybe, my
and
lords, maybe, my lords, but this
It's your
problem
duty.
has been faced by SSC across.
where is the
country.
problem there? SSCs are taking undue advantage.
No, my lords, the problem is that they do not intimate, my lords, in message or email. One intimation from them would have,
Intimation is provided for in the statute.
or is there, or,
It's not
or
mandatory.
is
It's not
there.
mandatory.
But that
Uploading
has been
itself is
accepted.
uploading itself is notice.
In a common portal, my lords, but that
This
place
is a
has to
common.
be- but that place has to be accessible, my lords. If they place it on obscure places, my lord, how will the assessor?
It's not obscure, it's on the same footing as view notices.
Yes.
I mean, only 4 headings below.
But my lords, this confusion is not just my problem, my lords. This has been faced by several assessees and several high courts have taken cognizance.
This has been well reasoned in the order impugned by the.
Acha, very well. Let us see, continue with the order. Yes, you are please.
Then thereafter it comes, the petitioner filed the belated appeal only after 7 months and 20 days from after the date of passing of the assessment order. The appellate authority, via its order dated 23rd of April 2025, refused to condone the delay. Accordingly, dismissed the above on the sole ground of.
Here also you have done it.
That was. And my lord, then comes the additional notices portal. There is the paragraph number 3. Learned counsel, Mr. Jalpaiguri submits the petitioner became aware of the assessment order on 12th of August 2024, only in the month of March 2025. It is submitted the said order was not available under the commonly as access tab. Under
Also, they
view
don't
notices
say
and
that
order.
they
That's the
could not,
contention.
don't say they could not access view additional notices.
That is their contention.
They don't say that.
They don't say that.
They don't say that. They say the common tab is view notices.
Yes.
It was not there,
Mm.
but it was intentionally uploaded probably under the additional notice.
Yes.
They don't say that we had problem in accessing additional.
Accessing the view notices and my lord, that explanation has been given in paragraph number 4. That is the contention of the petitioner's advocate has been replied to by the honorable court. My lord takes a paragraph number 4, the
Yes.
lower part. My lord, learned counsel further submits the medical documents. This is
Medical.
my lord, learned counsel further points out that the additional notices were also available on the same page of the portal. She further states that the note appended at the portal further clarifies the notices which have been appended on the portal under the view additional notices and orders. Learned counsel further points out the show cause notice itself shows that the petitioner was granted personal hearing as well as opportunity to file his reply to the. So this is with respect to the additional notices. And my lord, our contention is that the time period for filing that is the delay that has been put forth. He filed certain medical documents, prescriptions, which is led to in only particular 2 months. My lord takes up that is in paragraph number 4.
Yes, you have seen
This
that
was-
also.
this was
November to
submission.
January 25.
Yes, only with respect to 2 months. Now, the honorable single judge considered all those points.
Oh. How was SK Chakraborty dealt with? SK Chakraborty has been,
SK Chakraborty has not been delivered. My lord,
no, it has been quoted in para 5.
yes.
Para 5, the single judge says that the only issue which arises for consideration is that whether the
We are-
petitioner had shown.
You take a
sufficient-
seat.
My lord, SK Chakraborty is taken into consideration on the fact that authority has, by virtue of the order passed in SK Chakraborty, to condone the delay, if sufficient cause is shown. But there must be sufficient.
On facts here,
On facts, it's different. My lord, takes up paragraph number 7 of the impugned order. This is the explanation.
yes, in fact, the court has said in para 5,
Yes.
SK Chakraborty was considered,
Considered.
and thus the only question remains
Sufficient
whether
cause not-
had shown sufficient.
sufficient cause.
Then come to 7.
7. The appeal in the present case was preferred 3 months and 20 days beyond the outer condonable limit, bringing the total delay up to 7 months and 20 days. The medical prescription submitted explained only a part of the delay and failed to justify why the appeal could not have been drafted and filed during the substantial period from February 2025 to April 2025. Petitioner is a partnership firm. Even if one of the partners is indisposed, Nothing prevented the other partner to authorize or authorized signatory from acting. Section 169 1D provides that if any of the modes of service listed therein is sufficient service, uploading the order on the portal fulfills the statutory mandate. Supplementary intimation by SMS or email is facilitative but not obligatory. In the absence of any cogent or comprehensive explanation that covers the entire period of the delay, the petitioner has failed to demonstrate sufficient cause within the meaning of section 107(4). Consequently, refusal to condone the delay is perfect in consonance with the statutory framework and settled principles of fiscal. And thereafter, my lord, this issue has been taken into consideration. Now, the authority concerned under the provisions of section 107, if I may take up 107, does not have the powers to condone the delay beyond the 3+1 period.
But that several high courts have held that
only by virtue of the judgment of the honorable High Court, if there is sufficient cause shown beyond that period, that can be. In this case, no sufficient cause was shown. It was not sufficient on the part of the prescriptions as well as the delay that has been shown only pertain to a specified period of time.
so the learned single judge considered both the points.
Yes.
Considered that yes, SK Chakraborty is
Yes,
there, but
applicable.
in this case,
Yes.
huge delay, no explanation, and it was dealt with also one of the partners and all. That is one aspect, and the other aspect also that this is sufficient notice.
Sufficient.
That personal hearing aspect was also considered.
Consider.
Although this discrepancy of dates that has not been
Personal hearing.
dealt with.
That-
10th and 3rd.
Yes, 7 days difference.
We'll have to look into those judgments which your learned friend has cited regarding the notice
Yes,
period.
the judgments, I find that date of hearing has not even been mentioned in the show cause.
Those judgments obviously do not apply,
not
but the other judgments which
And my lord, the specific, that is the reply that has been filed after receiving the show cause notice, my lord takes up the relevant part of their reply. That is
Yes.
at page 75, I believe.
67 figure, like
So reply
67 on this.
67, my lord. So the last part, that is at page 70.
70 is.
And he takes up the last paragraph. Sir, we have provided a proper explanation for the discrepancies raised. Therefore, kindly close the proceedings accordingly. So, and they are asking to close the proceedings. Thereafter, they say you are requested
No,
not
they
to
say
pass any adverse order before giving a
whole letter underlined. So that they have taken care of that.
and then asks for giving a personal hearing.
We will look into it. And any reply regarding the sufficiency of delay? Two things. Learned judge has, because as my learned brother was pointing out, the limitation is a window.
Yes.
Unless we can enter through the window, then we cannot look into the other aspects of the matter. Personal hearing is of the next level. So even if personal hearing was not given, you argue that there are judgments which say natural justice violation is a ground itself.
Yes, my lord.
Apart from this medical and all.
Yes.
And but here the learned single judge says taken one of the plausible views, as in intra-court appeals we say, that 3 months delay, one of the partners' illness you have shown, but the other partners could very well have done it.
But my lords, here I join issues here because I am a two-person partnership firm.
Yes.
Both are real brothers.
One is a literal sleeping partner.
Both are-
Unless it's a literal sleeping partner, then
One was undergoing a surgery. Another one was taking care of the ill mother who was also facing some surgery. My lords. So it
people start taking care of the ailing parents in matrimonial matters when they are to give maintenance, and also in assessment cases we are now seeing. So the ailing mothers are at an advantage when these things happen. At least let them get some care. Very well. We'll look into it. We'll reserve judgment.
I'm grateful.
Thank you very much.
I'm grateful.
Hearing is concluded. Judgment is reserved in the matter.
I'm grateful.
We'll have to look through the judgments.
Yes.
Lord.
My lords, there is one more compilation I have.
No, on what point?
On this point where there is, appeal was dismissed as time barred, and despite violation of natural justice, courts have interfered. Our division bench as well. And SK Chakraborty, if my lords wants, I can.
SK Chakraborty is
It's not required because this is not on the.
SK Chakraborty is quoted by has been quoted by the learned single judge.
I'm grateful.
থ্যাংক ইউ এটা পাঠিয়ে দেবেন আর কি এই বইটা ওদের ফেরত দিতে হবে
Affidavit of service may be given.
হ্যাঁ একটা লাইন অ্যাড করে দিন। এই বইটা ওদের বোধেন না এটা ফেরত দিন। আমাদের বইটা তো আমার কাছে আছে ওনার থ্যাংক ইউ স্যার প্লিজ
Lordship, in item number 12 was called, I was.
Already over.
No, Lordship, it was fixed on 20th Monday. I will not be there. It may kindly be fixed on Wednesday.
If somebody there to pray for time, we've already fixed it on Monday.
Lord,
Just ask somebody, some of you, and give a notice to the other side so that they don't
I
come
want-
prepared.
Sir,
That will suffice. That will. Just ask for that adjournment.
Lord.
Yes.
And for the state,
Straight.
it's also GST matter.
None here for the appellant.
It's the matter, Monday, your lordship.
On the prayer of the appellant, the matter is adjourned till July 28, 2025. Give both of your names. Your name only for you. Yes. None appears for the parties at the time of you are appearing.
For opposite party number 4, my lord. There's been, they need to serve a copy on us, my lord.
You don't have a copy?
No, we do not have a copy.
Learned counsel having instructions. You are for the union.
I'm for the bank, my lord.
Learned counsel appearing for the
Number-
respondent bank submits that no copy of the papers have been served on the bank. Full the none appears for the appellant at the time of call. Full stop. The learned advocate for the appellant is requested to serve copies of the relevant papers in respect of the matter to the respondents. Let the matter stand adjourned till July 29, 2025. Thank you. Yeah, you try to communicate this order to your learned counterpart so that they can comply with this order. Yes. Yeah, for the tax order, right? Yes. Yes, right. On the prayer of the appellant, the matter is adjourned for the day. Yes.
Number 18.
My lord, item number 18, I am on behalf of the respondents, my lord.
Yes.
The other side has served the petition only today to my learned friend who is standing in court.
Yes.
Who is standing in court? You are standing in court. So you are for the respondent, Mr. Gupta.
My lord. So if my lord gives me some time to go through the petition at least and takes up the matter on Friday, my lord, I shall be better prepared. Actually, I am not even having the wakalatnama.
Very good. On the prayer of the respondents, the matter on the prayer of the respondents, since the papers have been handed over only recently to them, let the matter stand over till July 25, 2025. Friday.
I'm deeply obliged, my lord.
Thank you. Yes. এটা কোন অর্ডার হয়েছে আগের দিন আজকে এসেছে এটা কি মেনশন করে এনেছে সিঙ্গেল বেঞ্চে অ্যাপিয়ার করতে বলেছিল ভুল করছে হ্যাঁ এটা সিঙ্গেল বেঞ্চে ভুল করে আসছে তাহলে এলো কি করে অফিস পাঠিয়েছে দেখুন না None appears at the time of call. Let the matter stand adjourned till July 28, 2025.
Item number 20.
Same.
Item number 21.
For the respondent, my lord.
21.
Yes, my lord. And I'm led by Mr. Shojit Basu.
Respond, let the appellant come. দেখি ফাইলটা দেখি ডিফেক্টে কি আছে দেখিনি হ্যাঁ ডিফেক্ট নেই ওহো আচ্ছা None appears for the appellant, although the respondent is represented through counsel. Yes. What is the application? Ground, Mr. Poddar?
Sufficient.
In this matter,
Yes.
I beg to appear on behalf of the plaintiff respondent.
Right. What about the section 5?
They have said that due to, in paragraph 3, due to illness, they could not file, but.
Illness and paragraph
there is no
5 papers arranged and such thing.
And And the main thing is illness, but they have not given any
Not only
supporting
that, not only that, they
documentation.
have initially typed that all the documents are annexed and then they have scored
Yes,
through.
Lord.
Yes, there is nothing,
Nothing is
no
there.
illness.
There. Yes, Lordship.
और अच्छा लगी ही करे. What is the appeal against? Yes, we are taking a lenient approach, Mr. Vas. Heard learned counsel for the party. Heard learned counsel for the parties. Full stop. Next para. Learned counsel for the respondent points out that no proof of the illness of the appellant has been furnished. Full stop. Next para. However, comma, we find from the application that apart from the illness having been stated on oath, comma, the appellant has taken a plea that there was some delay in gathering and arranging the necessary documents and papers for the purpose of preparing the appeal and getting the same prepared. Push up. Upon a consideration of the averments and hearing learned counsel, comma, we are of the opinion that sufficient explanation for the delay has been furnished. Accordingly, Can 2 of 2025 is allowed, thereby condoning the delay. In preferring FAT 15 of 2025, push up, the appeal is deemed to stand registered and admitted accordingly. What is the other application? Stay will pass the preliminary degree has been passed. So we'll pass the usual order that the proceedings will go on, but no final degree shall be drawn up.
Perhaps drawn, Lordship.
No final degree shall be drawn up, but final degree proceedings will continue. Can 1 is an application for stay of application for stay. Full stop. The appeal arises in connection with a preliminary decree of partition. Full stop. We are of the opinion that in the event any final decree is drawn up in the meantime, comma, the appeal will be rendered infructuous. Full stop. Accordingly, Can 1 of 2025 is disposed of by directing the learned trial judge to continue with the final degree proceedings, semicolon. However, comma, no final decree shall be drawn up during pendency of the present appeal without the prior leave of this court. Full stop. You are for the plaintiff respondent.
Yes, Lordship. Yes, Lordship.
For the purpose of the present applications, comma, we deem it unnecessary to direct service of notice on the pro forma respondents. Full stop. Next para. The appellant shall put in view of the appearance of the plaintiff stroke respondent number 1 through his learned advocate, service of notice of the appeal is dispensed with as far as the respondent number 1 is concerned. Full stop. The appellant shall put in due requisites and postal costs for service of notice of the appeal on the pro forma respondent numbers 2 to 12 within a week from date. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. Full stop. The trial court shall, comma, however, comma, for the limited purpose of proceeding with the final degree proceedings, comma, retain a skeletal records of the matter. So next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Grateful, Lordship.
Thank you so much.
I was in court number 2, Lordship.
Which matter?
To item number 20.
What have you done?
Lordship, it's a restoration application.
We put it on some other day. Come back. What is the defect?
Lordship, in this matter, Mr. Momoni Rahman is appearing, Lordship. I am paying for 1 day accommodation, Lordship.
Memo of appeal has to be classified as memorandum of appeal from, you have stated original order. It has to be original decree. Have you got a copy of the memorandum? Mr. Ghosh, you are there? Mr. Ghosh, please ask him to carry out the necessary correction. Memorandum of appeal from original decree it has to be, and probably the name of the learned trial judge has to be given. We are adjourning it for the day. You are asking for a day. On the prayer of the respondents, the matter is adjourned for the day. Push up the learned advocate. Deficit court fee also. 9900. Adjourned for the day. Push up the learned advocate on record for the appellant is granted leave to carry out the necessary corrections to the memorandum of appeal to rectify the defects as pointed out by the stamp reporter. Full stop. The appellant shall also put in the deficit court fees. Can you do it by tomorrow? Very well. put in the deficit court fees by July 24, 2025. Adjourn for the day প্রথমে যেখানে লিখেছি না ওখানে adjourn till July 25, 2025. Friday. Give your names. Yes,
My Lord, I am for the appellant.
right.
This is a death reference matter, so if my Lord can fix it any day, my Lord.
We are taking up on priority basis, Mr.
Yes,
Dr.
yes.
Choudhury. Don't frustrate our efforts by taking.
I am ready.
Start the matter then. Because
Actually,
it's not our domain actually, death reference, but since the persons are languishing, so and uncertainty looming over their head whether they'll die or live. So death reference.
will leave my Lord because the.
That is what. But from their perspective, they're in behind the bars and they're thinking whether I will live or not. So let us take up the matters. Since you are here, we can take your assistance and start the matter. You are for the state. Who is for the state? Well, let him start this. You be present here.
Let me start with only 3 witnesses today, my Lord, and then we can, because I am not that ready to complete the entire appeal today.
এটা নেক্সট ম্যাটারে কি আছে হিলোল আছে হিলোল না এরপরটা চন্দা ঝা এটা
That is the appeal.
oh no these are all
Yes.
up to 25 is yours.
Yes, yes.
Who is in the next matter? Then let us ascertain whether the other matters, Mr. Saurabh Ganguly, you are ready in the next item. Who is for the state?
The state so that matter can be taken. Worship, the impediment is when I went to give the notice, it was found that the state, the case was allotted to me on behalf of the state event. So I refused to take it because I was not being engaged. So now they have to engage.
When did that happen?
I don't know.
No, you gave the notice when? When was it found out?
Because the
22nd is yesterday. Oh, then they won't have time. And Mr. Aniruddha Vishwas is ready.
he is important in this case.
My Lord, I have not received the.
You have not yet received it. And then
Morning, my junior informed me that there will be another death reference will be given to you.
all right. 28 item 28, 29. Who is appearing for the appellant?
I have 28, my Lord.
28, 29.
Aman.
Anirban Banerjee is there, yes.
Time.
Right. So if Anirban Banerjee is for the appellant.
Yes.
If he is not prepared, then we'll start your matter then, Dr. Choudhury. 27.
I informed that I have been appointed in this case. So I have to.
No, 20. So 27 you have been appointed. Yes. No, so 27 we are not taking up. We are starting with, we just tried to ascertain if the others are available. Otherwise, Dr. Choudhury, you just start your matter. We have up to 115. You make out some of the points and you are Mr. Yes. Mr. Chakraborty or otherwise ready in the matter? More or less ready. Very well. You get yourself prepared tonight. Let us start today. So oh, very well. At 1 p.m. we have a habeas corpus fixed. So up to 1 p.m. you have to.
Well,
don't waste time.
no, my Lord.
Yes.
So, my Lord, this is appeal, my Lord, arising out of from an order of sentence of death passed by the Learned Trial Court. My Lord, the offences were punishable under section 302 of the Indian Penal Code. Now, my Lord, I'll start with the FIR first. My Lord, the FIR was lodged by one Mr. Ronindranath Chakraborty.
You are challenging the very conviction itself.
Yes.
Not only the quantum of sentence.
Yes, yes.
Well, yes.
So, my Lord, in the FIR, my Lord, it was lodged by one Mr. Ronindranath Chakraborty. It's in page number 2. My Lord, I'll read the FIR first.
Yes.
It says, my humble submission is that I, Ronindranath Chakraborty, son of so-and-so, a resident of so-and-so, having been present at the police station, am lodging this complaint in this regard, that today, that is on 28th of July 2023, at approximately 2:15 a.m., I was informed over telephone that Mahatab Alam Ansari, son of late Rafiq Ansari, a resident of my village, had been murdered due to injuries caused by dagger, and his wife Momita Dash also sustained injuries on different parts of her body caused by dagger. After receiving the news, I promptly rushed to the place of occurrence, and I came to learn from the place of occurrence that at that night, a gang of about 6 robbers carrying lethal weapons with them, breaking in through the window of Mahtab Alam Ansari's house, entered the room with an intention to robbing. And after entering the room, they plundered the furniture of the room and killed Mahtab with dagger and injured his wife severely with dagger. At that time, both the sons of Mahtab were inside the room. They shouted, and having found opportunity, both of them fled. They could recognize one of the robbers and took shelter in the house of their next door neighbor and disclosed it there. Afterwards, the accused persons were caught at a place named Deomali by courtesy to the promptness of the young guys of the village collaborated with the help of Dhupguri police station. The accused persons are 6 in number. 2 of them are female. One is the nephew of Mahtab Alam, whose name is Aftab Alam, son of Soensu. All the 6 persons are residents of Delhi. I also learned that the said gang of 6 robbers had taken away some amount of money and other articles from the room.
Only Aftab was handed out the death sentence.
Yes. Momita Dash is under treatment at present. She is at Jalpaiguri. She and her sons would be able to recognize the accused persons after seeing them. It is therefore prayed before you, sir, that you would be kind enough to make necessary arrangements for punishing the culprits as per law and oblige thereby. So, my lord, from this FIR, there are 6 accused persons. My lord, out of 6, 5 were found to be juvenile. They were tried separately in the juvenile justice board. And my lord, since he was of 19 years old, my lord, he was tried in the court, and my lord, sentence of death was awarded.
After was 19.
After was 19 years.
Death sentence.
Now, my lord.
Death sentence.
Now, my lord, let's come to the deposition.
এটা তো হিয়ার্স, এটা পরে ইনভেস্টিগেশনে নিশ্চয়ই বেরিয়েছে, নিশ্চয়ই বেরিয়েছে, তা নাহলে কনভিকশন দেবে। সরি, হুইচ পেজ?
My lord, page 50.
Yes, 50.
50 is the deposition of the witness number 1. My lord, she is the injured eyewitness, the wife of Mahtab Alam.
Momita.
Yes, Momita.
Yes, right.
Lord, she says, Mahtab Alam was my husband. He was murdered by Aftab Alam and his 5 associates. Out of them, 2 were female and 3 were male. Aftab Alam is present in court today, identified. On 27th of July 2023, myself, my husband, and my 2 minor sons were sleeping in our respective room. And my husband with our 2 minor children, namely Rihan Alam and Ayan Alam, were in another room, keeping the lights on. I was sleeping in another room alone due to my illness. At about 1:30 at night, I felt that someone was standing inside of my room. When I woke up, I found that the accused Aftab Alam, who was son of my sister-in-law Mini, and his male associate were in my room. I identified them because the light of the room is on. Seeing them, I screamed and went and get out of my bed and started shouting. The accused Aftab Alam gagged my mouth and put a knife on my throat. I managed to give a bite on his finger. He also gave a bite on my left shoulder. I received cut injury on my throat when he put knife on my throat. Thereafter, he pushed me on the floor. When I fell down on the floor, both of them sat on me and started assaulting me with that knife all over my body, causing bleeding injury. I tried to get myself free from their clutches, but they continuing to assault me by the knife. Hearing my screaming, my husband woke up and tried to enter into my room, but he was forcibly prevented by other accused persons. At that time, I heard that my son started crying and saying to the accused persons to leave their father. In order to rescue my children, I acted like I was dead by stopping my breath. The accused persons felt that I expired, so they left me and went in the room of my husband. Other accused persons told Aftab and his friend to hold tightly my husband. When they left me, I came near the door of the room and saw that all 6 accused persons armed with knife were assaulting my husband by the knife, and due to their assault, my husband received bleeding injury all over his body. I hurriedly jumped through the window of my room and came out of my house and somehow managed to hide myself inside a boundary wall adjacent to our house. I heard from there that the accused persons were searching for me. At that time, I found that one dhalai machine pickup van was coming through the road. I requested them to stop there. On being asked, I told them to go to my house immediately to rescue my husband and two children from the accused persons. They brought me to the house of Ashok Roy, one of my neighbor. At that time, some of my neighbors came there and I requested them to go to my house to rescue my husband and children. After some time, they came back and informed me that my husband required treatment at the hospital and my two children are missing from the house. They also brought me to Dhupguri hospital. After preliminary treatment, I was referred to Shodor Hospital, Jalpaiguri, and on the next day, I was brought to Eveland Nursing Home, Jalpaiguri. During my treatment, doctor of Eveland Nursing Home recorded my statement on 1st of August 2023. This is my statement. It bears my signature. Let the signature be marked Exhibit 1. On the next day, I was brought to Anandalok Hospital, Shiliguri, where I was admitted till 7th of August 2023. Thereafter, I came to my paternal home. During my treatment at Anandalok Hospital, I came to know that my husband expired on the date of the incident due to assault by the accused persons. When I came back to my paternal home from the hospital, I met with my children, and from them I also came to know that the accused person threatened them to kill like their father. My sons also disclosed to me that their father requested the accused persons to take everything from the house, whatever they want, and also requested them not to kill him. My sons also told me that when the accused persons were searching for me and taking that advantage, they managed to flee from the spot and took shelter in the house of Ashwini Roy. They also told me that the accused persons were also searching for them. During investigation, police informed me to identify the accused persons in jail custody. I went to Central Correctional Home, Jalpaiguri, where I identified all 6 accused persons in presence of the magistrate. I gave my statement before learned magistrate regarding the alleged incident, and the learned magistrate recorded my statement as per my dictation. This is my statement. It bears my signature. Let this statement under section 164 CRPC marked Exhibit 2 and signature be marked Exhibit 1.
Dr. Chaudhary, the other 5 accused persons are unrelated with you or your...
Milord, they are not related to me. I can identify rest of the accused persons if they are present in court. The accused Aftab used to reside in Delhi. Now, Milord, the cross-examination. Yes. After marriage, I did not change my surname as I engaged in service. My husband had a business and he was also an agent of Shahara Company. We have one-story Pakka residential house with tin shed. We have 2 bedroom with 1 kitchen. Our house is not surrounded by any boundary wall. In the eastern side, there is the house of Ashwini Roy, and on the west, house of Ashok Roy. And in the south, there is road and thereafter school. And in the north, there is house of Ganesh Roy. House of Ashwini Roy is adjacent to our house. There is no iron grill of the window of our house at the relevant time, but at present, we fix grills in our rooms. We generally went to bed by 12 at night. On that night, my husband locked the door and windows of our rooms. Windows of our house are made of wood. My mother-in-law used to reside with us, but last 1 year prior to the incident, she went to Delhi and started residing there in the house of her another son. I am working as a para teacher in primary school. I draw salary around rupees 10,000 per month. My husband used to earn rupees 10 to 20,000 on average per month. When I stopped the dhalai machine pickup van, I found Patan Roy and 10 to 12 laborers in that pickup van. My paternal home is in the same locality near to my husband's house. Our marriage was the outcome of love affairs. My parents had objection against our relationship, but subsequently they accepted our marriage. The accused Aftab and his friend gave about 20 to 30 blows upon me by the knife. The size of the knife was 6 to 7 inches in length. The place where I hide myself was 20 to 30 feet away from my house. The house of Ashok Roy situates opposite to my house. The house of Ganesh Roy situates in between my house and the house of Ashok. There is no street lights in our locality. Now, next, I stated before the magistrate that the accused Aftab put knife on my throat and gave a bite on his finger. I stated before the magistrate the light of my room was on that night. After reaching the house of Ashok Roy, local people started gathering there. After 10 to 15 minutes, I was taken to Dhupguri Shodor Hospital. Ashok Roy and one of his friend of my husband told me that my husband sustained injury and requires treatment. At the relevant time, I was wearing a nightie and it was wet by blood. The nightie was torn in the house of Ashok Roy and I wear a fresh nightie in their house and taken to Dhupguri Hospital. During my treatment, I gave description of the accused persons about their height, complexion and looks to police. Out of two female accused, one was slim and another was healthy. All male accused persons were slim and tall. I went to correctional home with my brother. Thereafter, police came there. I went inside correctional home alone. Police told me to sit inside the correctional home. Police told me over phone that I have to identify the accused persons in correctional home. All four male accused persons were mixed up with other male persons inside the jail, and I was asked to identify male accused persons amongst the male persons standing there. During TI parade, I identified all 6 persons from close vicinity. After discharge from the hospital, when I came to my paternal home, I heard that the incident was reported in all newspapers and news channels. I did not see newspapers and news channels at the relevant time because I was admitted in the hospital and I was not allowed to see my mobile phone. At the relevant time, I was in drowsiness as I was suffering from typhoid for the last few days. Not a fact that prior to TI parade, police identified the accused persons to me. Not a fact that the accused Aftab did not put knife on my throat and gave a bite on my shoulder. Not a fact that the accused was not involved in the alleged incident. Not a fact that I identified the accused through TV channels. I was so injured at the relevant time that I could not see the registration number of the pickup van and its color. Thereafter, Milord, general denial of not to have. So, Milord, from this evidence, Milord, three things comes up. The first is the identification of the accused in the TI parade. Milord, second is the entry of the accused persons in the home, because in the evidence she says that they have jumped over the window. But during the cross-examination, she says that the doors and windows were locked from inside, but there is no evidence saying, Milord, that the windows were broken, or during that time, Milord, it came to the light of the persons residing inside. Milord, there were 4 persons inside. Milord, none of them came to know that the windows were broken. Rather, there is no evidence saying that the windows were broken.
All right.
Lord, another thing is that Lord, she says that after receiving the blow, Lord, she goes away. Somehow she saves herself and she goes away 30 feet away from the house. And thereafter she stops the van, Dhalai van, and calls the laborers, and they takes them, all of them takes her to a neighbor's house. But Milord, from the subsequent evidence, Milord, Lord, she will find that the neighbor in whose house, Milord, she
Ashok Roy,
Milord, the version of the neighbor is bit different from the version of
What was his PW number? Ashok Roy?
Milord.
What was he was PW?
Ashok Roy is Milord PW. PW 15, Milord.
Very good. Very good. You proceed in your own way. Yes.
Yes. One more aspect is the TI parade. But the TI parade, it was widely reported in the newspaper, in the media, in the local news channels, Milord, that such an incident has happened. And Milord, it was already, Milord, flashed by the news channels that this so and so persons were the accused persons. And after that, Milord, the TI parade was conducted in the jail. So, Milord, somehow that vitiates the TI parade as well, because the identity was already revealed to the witness prior to conducting the TI parade.
No, were they arrested before she gave a statement?
Yes.
Obviously, sorry, the TI parade could not. So they were arrested, and you say it was flashed on the media who these people were, and then
yes,
she could have been
yes,
have a cue from there.
Yes, yes.
Just my lord, thing is that when they were arrested, they told because they booked a hotel saying that they're 18 plus. No, why they were in jail? Because if they're juvenile, they are not supposed to be in the jail.
Right.
So that has to be clear. The thing is that at the first instance, they gave the documents which showed that they are juvenile, they are major, because all those were fake documents which were produced before the hotel for their stay. So on that basis, police arrested them and police sent them to jail. Later on, they showed the documents and they were sent to the home. That's why 4 accused persons were identified inside the jail.
So they were in jail for a different reason.
Jail only because they showed the documents which showed that they were.
The hotel
major.
ascertained that it was false document.
Later on, it was ascertained. On the day when they were arrested and sent to jail.
They were arrested for what? Not this offense.
For this offense, they were arrested. They were arrested from the spot. The
On
villagers-
jail for that purpose.
Jail because they told
Very
their
well.
major. That's why they were sent to jail. Later, their relatives, their parents brought the documents that they are juvenile. Then
Good.
they were sent to the.
No difficulty on that. For the present.
4 persons were identified.
Acha.
Now, my lord, PW2 is one of the son of the PW1. Ayan Alam, my lord.
Yes.
My lord, it starts from 55.
Right.
My lord,
Yes. Yes, we can start.
well, it says, question number 1, my lord, these are the questions put to the witness by the court because he's a child witness, my lord. So I'll start directly from examination in chief, page 56. Lord, Mehtab Alam was my father. He was killed by Aftab Dada and his friends, 5 friends, out of them 2 were females. Aftab Dada is present in court today and identified. Now, my lord, Aftab is connected, my lord, the deceased person is the maternal uncle of Aftab. Now, my lord, on 27/7/2023 at about 10 p.m., myself, my brother Rihan Alam, my mother Momita Dash and my father were in our house. Myself, my brother and my father were sleeping in a room and my mother was sleeping in another room due to her illness. At about 1 to 1:30 at night, we woke up after hearing screaming of my mother. When my father was trying to enter into the room of my mother, 4 persons came out from the kitchen and started assaulting my father with knife. At that time, light of the room was on, so I identified those persons. My father sustained bleeding injury. Thereafter, Aftab Dada and his another friend came out of the room of my mother and started assaulting my father with knife. When myself and my brother were trying to come out of the room, one of the female accused told us, "तुमको भी तुम्हारी पापा की तरह मरना है." My father told, मेरा 2 बच्चा है, मुझे छोड़ दो और जो चाहिए वो ले लो. The accused persons also told that भाग गई and started searching my mother. When they were searching for my mother, I hurriedly fled away from the room and took shelter in the house of my Jethu Ashwini Roy. The accused persons also started searching for us. We stayed in the house of Ashwini Roy in that night. Myself, my brother and my Jethu went to jail at Jalpaiguri for identification of the accused persons. I identified all 6 accused persons in jail. I gave my statement before the learned magistrate in court and I put my signature on the statement in English. This is my signature. Let the statement be marked Exhibit 3 and the signature be marked Exhibit so and so. The accused persons also assaulted my mother with knife. My mother told me that Aftab Dada and his friend assaulted her with knife. Now let the cross-examination. I stated before the magistrate that I took shelter in the house of Ashwini Roy. Door of our room was made of wood and it was locked by chitkini. The chitkini was fixed on the middle of the door. When I fled away from the room, my brother was still inside the room. I went inside the jail. No one asked me or identified the accused persons before me inside the jail. 4 male accused persons were mixed up with number of male persons inside the jail. Female accused persons were also mixed up with number of female persons. I do not watch TV. I never seen the accused persons in the TV. The face of the accused persons were not covered by mask when they entered into our house. Not a fact that the accused persons did not assault my father with knife and thereafter general denial, my lord. So, my lord, from the evidence of this witness, my lord, here also the primary thing that comes out is, my lord, how the accused persons entered the house. My lord, he admits in the cross-examination that it was closed from inside by a chitkin. But, my lord, there is no evidence adduced by the prosecution that how the door, either the door was broken. My lord, some method or methodology has to come in the evidence as to how they have entered the house. Either they have broken the door or they have broken the window. But, my lord, we have found different contradictory evidence from the mother and the son.
Where is the contradiction?
My lord, mother says they have come from the window.
He does not say they came through the door.
Yes.
In cross-exam, he says,
yes,
he does not say anything on that.
Yes. Lord, PW3 is, my lord, another.
The habeas corpus are both sides present. Other side is also there. Dr. Chaudhary will end here today and we will take up that matter. Hard in part for further hearing tomorrow. Great. এটা একটু পেপার বুকের সঙ্গে স্টেপল করে দেবে পরদিন পেপার বুকটা দিলেই হবে আর এটাও সাইডে দিয়ে রাখবে হ্যাঁ আমরা বলে দিয়েছি পরের দিন এই সিভিল অ্যাপ্লিকেশন অর্ডার ফর টোয়েন্টি পর্যন্ত থাকবে তারপর সিভিল অ্যাপ্লিকেশন প্রাপ্ত হয়ে যাবে তারপর এইগুলো থাকবে হ্যাঁ ম্যান্ডামাস সব চলে চলে অ্যাপ্লিকেশন অ্যাপিল যা থাকবে ম্যান্ডামাস চলে চলে যাবে ডেথ রেফারেন্স সিভিল অ্যাপ্লিকেশনের পরেই এবার হ্যাবিয়াস কর্পাসটা
Number 32. And
Yes.
statement.
What is the matter?
Well, in this matter, petitioner is the unfortunate husband, my lord, whose wife, my lord, on 16th of June 2025 went to market, my lord, for buy some clothes for his minor children, and my lord, thereafter she did not return, my lord.
So what is your allegation? You approached anyone? You lodged a complaint with the police?
Yes, my lord. Thereafter, on 17th, I filed an
You lodged a missing diary?
missing diary, which is page 21, man. Before the officer in charge of police station, Pundibari police station, but till date, my lord, they did not show any adherence to, my lord, recover my wife, my lord. My lord, the petitioner have two minor children, my lord, one is 9 years and one is 14 years, my lord. And my lord, the wife of the petitioner is only sole caregiver of the children, my lord. And my lord, petitioner is the working husband, my lord. There is no one is home, my lord. If the, my lord, the wife of the petitioner is not recover, my lord, it will be difficult.
Yes, what do you say?
So one person, namely Taposh Kundu, and the husband very well knows about the same.
How do you say that? Husband knows?
There is another refer on law.
As by instruction, it says that the petitioner is well aware that the wife has eloped with one Taposh Kundu.
What, any report, police report or anything? You have to give copies to them also.
My lord, I have one set, my lord. I am led by AGP in the matter, my lord. He has another report, my lord. I'll supply in the.
Supply during the course of the day. We'll put it as to be mentioned tomorrow. We'll put it as to be mentioned tomorrow. We'll pass orders on this. So that is the only scope of the habeas corpus. You circulate copies, whatever you have to him. The learned counsel for the petitioner complains that the wife of the petitioner, comma, who is the sole caregiver for the two minor children of the petitioner, comma, respectively aged about 9 and 14 years, comma, went missing on June 16, 2025 when she went to the market to fetch certain things. For the next para, the petitioner is a working husband and as such, comma, is in much difficulty since the minor children of the petitioner are uncared for. Moreover, comma, it is contended that despite having lodged a missing diary, comma, no information regarding the whereabouts of his wife were furnished to the petitioner. So next para, learned counsel appearing for the state submits on instruction that how did you get the information? No, the police got information how? After his missing, on his missing. Learned counsel for the state submits on instruction that the police, comma, on an inquiry on the basis of the missing diary lodged by the husband, comma, have come to know that the wife has eloped with one Taposh Kundu. Since the necessary instructions in that regard have not been furnished as yet to the learned advocate for the petitioner, comma, we request the learned counsel for the state to hand over all relevant documents in that regard to the learned advocate for the petitioner during the course of the day, full stop. The matter be placed in the list tomorrow at the top under the heading to be mentioned. Continue করি তাহলে তো হয়ে গেল অর্জুনকে আবার ফেরত আনতে হবে না পরের ম্যাটার ডাকুন পরের হেভিয়াস কর্পাসটা ডাকুন লেট রেফারেন্স যেগুলো আছে ডাকুন ফর্মালি ডাকুন আমরা নোট করে না থাকি 26, yes, there was some problem. This is the matter where you are engaged for both the parties. So, should you keep it tomorrow?
Bishop has been appointed, but
He is not ready, he said. Not Monday. We'll keep it tomorrow. Ask Mr. Vishwas to be ready because these are death reference matters. You are prepared for one of the.
Yes, sir.
You are prepared with your appeal. So you start hearing tomorrow. Learned counsel appearing for the petitioner apprises the court that recently, he was sought to be appointed on behalf of the state as well, which he obviously refused since he is already appearing for the petitioner, full stop. Accordingly, to enable the state to engage new counsel and for such counsel to be prepared in the matter, let the matter stand adjourned for the day. Thank you.
Worship, this is the said matter where
The death reference. No,
Death reference.
both are death. Oh, three separate accused. I mean convicts.
no 27 is another case, Worship,
Another case. So here, what is it? You are for the state. For the petitioner. What about the state? They're not appearing. Give a notice. We'll take it up tomorrow.
Lordship,
Day after.
no, it's not that, Lordship. It was directed that a senior be engaged. An advocate sufficiently senior can be engaged on behalf of the DLSS to fight for the accused.
You are that.
But can a junior be engaged as well, Lordship, to assist me?
Yes. What is your full name? On the prayer of learned counsel. On the prayer of learned counsel for the petitioner, who has been appointed by the District Legal Services Authority, High Court, by the High Court Legal Services Authority, Mr. Abhishek Sarkar be appointed as junior to Mr. Ganguly to assist Mr. Ganguly in the matter. First of all, let the engagement of Mr. Sarkar be regularized by the High Court Legal Services Authority. First of, since none appears for this, you are appearing for the state. Since none appears for the state on behalf of, since none appears for the state at the time of call, let the matter stand adjourned till tomorrow. Please give a notice to the state formally and day after tomorrow. Acha very well. Adjourn till day after tomorrow. That is no, not yes, Friday. That is till July 25, 2025. Thank you.
Oliver Banerjee is for the appellant, I am for the
State.
DR part.
But you are for the state.
No.
Or you are for the petitioner, for the convict. The death reference, the scope is same in the appeal and the death reference. There are judgments, you know, that death reference court has to look into all the aspects of the matter, look into the evidence also. So you apprise us of what is the. You have not appraised yourself as yet. No. Who is appearing for the state, right? Aniruddha Vishwas. No, oh, sorry, that's you. Mr. Banerjee, no, he's for the appellant. None appeared for the state on the last occasion. Additional public prosecutor was present. Mr.
Yes.
Chakraborty was present.
Yes.
Mr. Subhashish Mitra was with him. The none appears for the state at the time of call. Full stop. The learned advocate appearing for the convict in the death reference is requested to serve a notice on Mr. Subhashish Mitra, the learned advocate who appeared for the state on the last occasion, indicating that the matter shall be listed next tomorrow. Let us keep it tomorrow. If he has difficulty, we'll see. Mr. Banerjee has come. Please, in your slip of paper, please write you are for the appellant and you for whoever. I mean, give the reference that you are appearing in the appeal and you are in the death reference. It will be recorded like that. For it.
28 is the death.
28, I mean, we're not to 29.
Right, right.
My lord, item number 30, the service has not been completed upon the private response.
So next circuit,
My lord, kindly.
on the prayer of learned counsel for the petitioner, comma, to enable the service to be completed, let the matter stand over till July 28, 2025.
Next week, I missed that.
You're for the petitioner?
Yes.
On the prayer of the petitioner, the matter is adjourned till till July 28. Yes. The estimator better keep on the next circuit. As very well. On the prayer of the, you are for the appellant. On the prayer of the appellant, the matter is adjourned till July 28, 2025. None appears, adjourned till July 34.
I'm the appellant petitioner.
You are appearing in person? Very well. What is the matter about?
Forgery. Yeah.
You argue your matter? আপনি বাংলায় করবেন না ইংরেজিতে করবেন? একদম করুন।
আমার সিগনেচার ফরজারি হয়েছে বেলবন্ডে।
না এটা 34 হচ্ছে আপনি সুখেন্দ্রনাথ বণিক। এটা কিসের এগেইনস্টে চ্যালেঞ্জ করেছেন? সিঙ্গেল জাজের কোনো অর্ডার? না না, এটা কিসের কানেকশনে অ্যাপিলটা? অর্ডারটা কি ছিল? ফাইলটা দিন। ফাইলটা না পেলে কি করে? সেটা ম্যান্ডামাস অ্যাপিল কি করে হচ্ছে? কি হচ্ছে?
Who is for the other side?
Mr. Hirok Bormon, where is?
What is this matter? Could you price this one?
কি অ্যাপিল অর্ডার? জজ সাহেবের ফাইলটা দিন। বুঝছেন? দাঁড়ান দাঁড়ান। আপনি কোর্ট মনিটর ইনভেস্টিগেশন চেয়েছেন? লার্নেড সিঙ্গেল জাজ সেটা দেননি, দেখা যাক কি অর্ডার হয়েছে। ওই অ্যাপিলের এটা কোথায়? সিঙ্গেল জাজের অর্ডারটা কোনটা? মেমোটা কোথায়? মেমো অফ অ্যাপিল এখানে নেই? এটা? হ্যাঁ ঠিক আছে, পেয়েছি।
Yes.
আপনি বলছেন আপনি বেল বন্ডে সিকিউরিটি হিসেবে সই করেননি? Yes, Mr. What is the case about? He alleges that his signatures were forged on a bail bond given for someone else, obviously. Is there any relation between the two? What is
the nephew, Mela?
the other person is the nephew? So forgery, he asked for an investigation.
Not a practicing advocate there in Alipurduar.
You are practicing advocate? The nephew?
He himself and nephew is both. They are the
আপনি
practicing.
অ্যাডভোকেট?
That's
আপনি অ্যাডভোকেট না অ্যাডভোকেট নন?
Lord, what happened? There was a private
সে তো বুঝতে পারছি, yes.
So there is a private dispute with regards to a property, Mela.
Right.
My lord, after a lapse of 10 years, he filed a complaint. That
He filed a complaint.
He filed a complaint.
Right.
He filed a complaint against the accused, my lord,
All right.
alleging that in the name of the his name,
আমরা আপনাকে শুনবো, মানে ফ্যাক্টটা শুনে নিচ্ছি ওনার কাছে। Yes.
his name, the bail bond which has been stood as a surety, my lord, appears to be impersonating his name. The bail bond was submitted.
Right.
The Lane district judge was, my lord, requested to cause an inquiry. The Lane district judge submitted a report with regards to, my lord, around 2,900.
After 10 years from the incident.
Yes, my lord.
After 10 years from executing the bail bond.
Yes, because in between,
Huh.
he also, my lord, attending in the chamber of the, my lord, his nephew.
Yeah, never.
আপনার বাবাকে সিট দিন, বসান। হ্যাঁ, yes, you can make submission, কিন্তু বাবাকে আগে বসান। বাংলায় নিজে, হিন্দি সব চলবে, আপনি আগে বসান বাবাকে, দাঁড়িয়ে থাকতে হবে। আপনি নিজে দরকার হলে কোনো চেয়ার পেলে বসুন, না চেয়ার পেলে ওনাকে সরিয়ে বসুন। Yes, you can assist. We have permitted you. After, yes. Yes.
So, my lord,
What was the bail bond regarding? What was the offense?
My lord, there are various offences, my lord.
Like, in the nature of?
Like, my lord, the
Forgery types or something else?
Forgery, my lord, even there is a smuggled items.
All right. So that bail bond, he filed a complaint after 10 years.
5-4, which Lane district just submitted a report, around 2,954 bail bonds were forged.
Achha. Including
His name. He stood as a surety, and his signature, what he's claimed, that it is not his signature.
Right.
In his name, the 2,954 bail bonds were.
So he lodged a complaint with the police.
Yes.
So what is now in the writ petition? He wants a
Then, my lord,
investigation.
Yes, then my lord, my lord, SIT was formed. My lord, the SP.
SIT was formed by the district judge.
My lord, by the SP Alipurduar.
SP, right.
He was monitoring the matter.
Yes.
My lord, your lordship will see that there are consecutive reports filed by me, by the SP, my lord, the SIT.
We'll look into that, yes.
Yes.
What is his allegation in the writ petition? What is his prayer?
Prayer is that the police did not take appropriate
Steps.
The challenge, the writ petition was dismissed. He preferred an appeal. And there are, my lord, the series of orders with regards to the investigation to cause an investigation.
Through that SIT itself?
SIT, by the SIT.
By the SIT. By
Then, my lord, what?
Yes.
Then, my lord, almost on the verge of the completion, my lord. Then, my lord, we thought that led the matter, because, my lord, kindly appreciate the certain, the personnel also involved from the judiciary, my lord.
All right.
Because, my lord, the custodian of the bail bond, surety register,
Very well, yes.
these persons are required to be interrogated.
Right.
So, SP was facing little bit difficulties, but I am candid.
No, understood, yes.
Then, my lord, matter was handed over to the CID.
Right.
CID now, my lord, the last occasion, my lord, 2 months back, it was been handed over. CID, my lord, had also caused an investigation. Progress report, my lord, it is in a sealed cover, it has been filed.
Achha. Very well. And what that was filed before the appeal court?
Before this, my lord, this honorable court.
We are hearing that
Yes,
appeal. It is in connection with that appeal.
Yes, yes, my lord. That is the sealed cover.
The impugned order of the learned single judge is that refused.
Dismissing the writ petition.
What was his prayer there? To ask for a seat?
No, ask for proper investigation.
Proper
To
investigation.
be carried out.
So now it is a court monitored thing in a sense.
Yes.
Not court monitored, CID.
Yes. No, definitely, my lord, court to some extent had.
What is the
outcome
progress
is-
of your yes?
Progress, my lord, we have forwarded all the bail bonds maximum, because 2,954, around 600 bail bonds were seized, was handed over to us.
600 bail bonds
Relating to these signature, forced signature.
the same person's signature.
Yes.
And it's obviously a forgery.
Yes. So, my lord,
So what is the outcome of that
Outcome-
investigation? Have you lodged the filed a charge sheet as yet?
Charge sheet, my lord, we was about to, my lord. The investigation more or less completed. In that juncture, my lord, it was handed over to the CID.
This report was filed when? How long
This
back?
is the last occasion, my lord. If your lordship see the previous reports,
No, we will ask you to file a current report and
current
we'll
report, also, my lord, but I am having.
Mr. Chaudhary,
My lord, I am having.
file the charge. Why don't you file the charge sheet and come back?
Charge sheet, my lord, we are contemplating to file charge sheet.
If you are contemplating, do that and come back on Friday. We'll keep it on Friday.
Friday, I don't, my lord, kindly fix in the next week, any day, my lord. In the meantime, I will.
You are
have
the
it.
CID. What's the difficulty?
No, there is no difficulty.
You have a
my lord.
TV show in your name also. So You should do it, you should have done it by yesterday. So what is the delay? Why, what is the reason for the delay in filing the charge sheet? You're
Actually, not
contemplating,
only there are so
where is the
many-
scope of
so many-
contemplation of CID?
Though so many advocates are involved.
So what?
No, it's not so what, my lord. Question is that in also.
It's absolutely so what?
No, my lord, the.
Advocates, judges, so what?
No, my lord, the question is.
That is
my
why
lord,
you
we
have been
require
entrusted.
The interrogation already my lord.
So if judges is a consideration or advocates is a consideration, we have to hand it over to the CBI. And now CBI will file a appeal saying that they are too overburdened with other matters.
My lord, kindly keep it in next week, Monday.
How is the CID bothered? I mean, they will follow the law and they'll file a charge sheet.
Definitely, no one is a
If
bother.
judges are concerned, even High Court judges are concerned, their names should be there in the charge sheet. After that, they will have to face the music. Trial will commence, they have to prove.
Exactly, they have to. And the district judiciaries, my lord, the certain personals are also
আমরা
involved in
পরের
this
সপ্তাহে রাখছি, শুনলেন তো? হ্যাঁ, আপনাদের কি বলা আছে বলুন? কি অর্ডার, কি কারেকশন, কি ধরনের কারেকশন, কি ধরনের কারেকশন? স্পেলিং মিস্টেক, এইসব নামের ভুল এসব? হ্যাঁ,
But the order has given against the.
oh, those don't matter. We cannot rectify other judges, but the facts will record. And since they are on the verge of filing a charge sheet, let them file the charge sheet. We'll ask for a final report and.
Charges has been filed against it, respondent number 8 by the SIT matter, so not by the
No, charge
SIT. At that moment, only SIT has been handed over by the state.
Charge sheet was filed.
I am informed, IO of the SIT has been.
No, the CID will give a report. That will disclose everything. We want a current report. The present matter arises.
Isn't it? Because I haven't seen even.
No, Mr. Chaudhary, we propose that you file a report. You go into this comprehensive report. So multiplying reports won't do. You put these things in that and give a final, the last status report. Yes.
Short one day
Mentioned as? So you have been elevated. But now an FIR may be lodged against you also.
He's also a student of law, pursuing law. So,
Yes, she appeared online, we have seen.
oh,
That is the impression we also got, but
The
we.
impression was that she's
No, she's very competent. She would have been a very good lawyer. Anyway, those mistakes are immaterial, forgiveness. The present appeal arises in connection with the rejection of an application filed by the appellant stroke writ petitioner for seeking a proper investigative action under the supervision of this court. Full stop. Next para. The genesis of the cause of action is that that several signature the signature of the petitioner stroke appellant were forged in numerous bail bonds and other documents, comma, for which a complaint was lodged by the appellant. Full stop. Thereafter, comma, as per the allegation of the appellant, comma, due investigation was not properly being done by the police. Full stop. Next para. Learned senior counsel appearing for the. Oh, sorry. Learned, you are the AG. Learned AAG appearing for the state submits that the matter that initially the superintendent of police, comma, who under whom a special investigating team within bracket SIT had been formed, was facing some embarrassments, comma, since the names of certain members of the profession and if
Option to you already.
since certain names of some of the members of the judiciary were featuring from such investigation, push up accordingly, comma, subsequently the investigation was handed over to the CID, which is now investigating the matter. Full stop. On query of court, comma, Mr. Chaudhary, comma, learned AAG apprises the court that the investigation is on the verge of completion and a charge sheet is about to be filed by the CID. Full stop. This court expects that such charge sheet shall be filed at the earliest and a complete status report as to the investigation, comma, including the filing of the charge sheet, comma, if so filed in the meantime, comma, shall be filed in court on behalf of the CID on the returnable date, full stop. The matter shall next be listed on July 29, 2025, under the heading to be mentioned at the top, to be mentioned. 29th July is next Tuesday, to be mentioned, it will be at the top. You file that report. For the present, need not circulate a copy to them because you are not yet entitled. If you feel you are entitled, we'll let you know. Thank you. Pardon?
Admission, FMAT MB matter, for admission hearing.
FMAT admission
Yes, my lord.
has to go before the division bench. Admission hearing division bench.
FMAT MB, motor accident claim, my lord. Admission hearing.
Admission hearing is required for that. Formal admission is required. Yes. Hearing second appeal, we cannot add any further. Acha, very well. Hand over. Let us give it. Put it in. Yes.
May I permit?
What?
CO.
Yes.
Civil division application.
Yes. Yes.
One day lordship, but not appeared lordship.
আসছে না কেন দেখুন তো।
Kindly taken up the matter.
Yes.
Second appeal, lordship, which I have moved today morning, item number 1. This is for
Stay application.
stay
Yes,
application.
son.
And one motor vehicle application also.
Very well. Hand over.
Appreciate.
Two civil divisional appeals.
Yes.
Yeah.
Lordship, if I may be permitted to mention, Lordship, writ petition application and tax matters, Lordship.
Writ petition.
Lordship.
Writ petition mentioned before the writ petition benches, the other benches.
Great.
Yes. The by an order dated July 22, 2025, comma, this court had recorded that it was the second occasion when none appeared for the parties at the time of call. First of all, last chance was accordingly given to the petitioner to move the matter, for which the matter was adjourned for the day. Full stop. Even today, comma, at the time of call, comma, none appears for the parties. Full stop. Accordingly, can 1 of 2020 is dismissed for default. Full stop. Consequentially, consequentially, SAT 4 of 2019 is deemed is not admitted as time barred. No address to costs. Same order.
I'm for the appeal.
I am for the.
Right. This is a section 5.
What?
Appeal has been admitted. This circuit.
Yes. No. Earlier.
Yes. Why you waited for so long?
2023. Must have been waiting for your lordship.
Yes. Stay, you have asked for stay has been.
Stay has been granted by your lordship.
Eviction suit. Where will direct we dispose of the application? No, but occupation charges. Did you direct it to file opposition?
No, I've been depositing before the district judge.
File your opposition, Mr. Bhattacharya. How soon can you file that?
2 weeks.
Very well. Then the stay continues. Enjoy the stay. The
Till the disposal of the application. Stay is till the disposal of the application.
yes. The application is not disposed of, it remains. They're asking for opposition. Would you like to file an opposition, or should you dispose of and direct them to paper? Whatever you say.
My opposition will only, my lord.
Deal with the matter. You will get occupation charges. What is the last rate at which you are paying? Before the district judge? 3,000 per month. We'll direct that to be paid as a condition. You have paid up to the dismissal of the appeal before title appeal. So we'll direct you to pay from the date of the impugned judgment of the appellate court. After that,
I've been paying money. Take instruction from that. If my lord,
you will put in an if any.
or maybe come back to my lord. My learned friend comes with the instruction till what time?
No difficulty, yes. Mr. Paul, come back tomorrow. Both of you ascertain how far you have paid. We'll put it from that date.
Great.
On the prayer of the parties, the matter is adjourned for the day. Yes, you. Why didn't you appear on the last occasion? None appeared.
But item number 4.
Item number 4, yes. Mr. Bhattacharya, you are appearing.
Yes. I maybe wrong. I am appearing. But 21st, practical,
You
I
received
missed
the
the
copy
matter.
today. Today only I have served a copy.
Today. But previously we have copy of the application upon the opposite party by post.
Oh,
Who
I
is
see,
up?
sir.
Who is
Oh.
up? That partial lordship direction we have served today. That twice we have served it.
Sir, are you prepared in the matter? Today you have been served, come back tomorrow. Revisional application, it will take 10 minutes to prepare.
But it will be tomorrow.
Tomorrow, Mr. Bhattacharya. Don't
But
scratch your head.
but a
Online,
candid-
online, all the same. If you appear
No,
online, all the same.
But a candid confession, but may I show a sense of But I have a matter is a daily, my lord. I do not know whether that will be decided. I may go. That is the if you also can take it in. All right, I shall try. I shall try, my lord.
We'll put
If
it
I
tomorrow
have-
if you are in difficulty.
Even
But have
difficulty, I shall-
somebody, otherwise we'll dismiss. Yes.
Bravo, if paper I had done with also.
Learned counsel for the petitioner submits that copies of the revisional application had already been served by post.
Yes.
However, learned counsel for the opposite parties submits that a copy has only been received this morning. Be that as it may, to enable the opposite parties to prepare themselves in the matter, let the same stand adjourned for the day. Kal
Yes,
third.
sir. Yes, yes, yes. So.
Yes. Yes. Yes, Mr. Dotto, what is the matter? Civil division?
Civil division.
Short question, what is the short question?
This is revision against the order of police self that has been passed by the learned trial court. My lord, kindly come to page 71st. 71. This is a peculiar case.
Who is for the other side?
Other side,
What about service?
no direction for service was given.
Let us see the previous order of Justice Chattawad. Police cell for implementation of an ad interim injunction.
Interim.
You are the defendants. You had made a put-up petition.
Yes.
What happened to that?
No, that is no reflection is in that in the order sheet. And now out of a sudden.
Yes, Shia book was called for.
Yes.
এটা কি রিপোর্ট এসছে কোন ট্রায়াল করতে গেলে রিপোর্ট কল ফর হয়েছিল আগে সার্কিটে রিপোর্ট কল ফর হয়েছিল আর কিছু আছে পেপার এখানে we find from the order dated the impugn order was stayed.
No order.
Then it has not been implemented in the meantime.
No, the police is disturbing. That is police implementation for.
Why you are not?
The decree, actually one decree was passed in our favor.
Acha.
In this petition, kindly come to page number 71. In the plaint itself, they are stated. Para 11 of the plaint.
What is this suit for? The present suit?
Present suit is for
partition.
preliminary
What was the degree passed there?
Decree or declaration of title and permanent injunction.
Your exclusive title in respect of the property.
Yes.
And permanent injunction.
Yes.
So this police help will be contrary to that.
Yes, against that injunction order is passed and police help is given.
We find from the order dated September 4, 2024 that that a coordinated bench had recorded the short background of the case and sought for a report from the trial court as regards the status of the put-up petition filed by the allegedly filed by the present petitioner on April 10, 2024. Full stop. Next para. However, comma, when the matter is placed before the court today, comma, I do not find any such report having any such report with the records. Full stop. Let the order dated September 4, 2024 be communicated immediately to the Civil Judge Senior Division at Jalpaiguri for the purpose of filing of such report. Full stop. Such report shall be filed within 3 weeks from the date of communication of this order to the said court. Full stop. The office shall take steps immediately for the purpose of such communication. এটা একটু অফিসকে বলে দেবেন অফিস যেন অর্ডারটা কমিউনিকেট করে দেয় নেক্সট প্যারা the premise of the revisional application is that the revisionist petitioner had obtained a decree of declaration the revisionist petitioners had obtained a decree of declaration of their title and permanent injunction in respect of the self-same property, comma, which fact has been admitted by the plaintiff stroke opposite parties in the present suit for partition. Full stop. In connection with the present partition suit, comma, the learned trial judge had granted an ad interim order of injunction. Full stop. Subsequently, an application was filed by the plaintiff stroke opposite parties for the purpose of implementation of the ad interim order of injunction by police help, with police help. Which of such application was allowed, comma, as per the allegation of the revisionist petitioner, comma, behind the back of the petitioner without giving any notice of the same to the petitioner. Full stop. Next para. I find from paragraph 11 of the plaint of the present suit that the fact of the filing of the previous suit, the fact of the previous decree passed in favor of the revisionist petitioner is admitted by the present of plaintiff stroke opposite parties, comma, although it has been alleged that it was a double inverted mode false double inverted civil suit. Full stop. Next para. Thus, comma, an arguable question has been raised in the revisional application as to whether the learned trial judge was justified in directing implementation of an ad interim order by police help, comma, in the teeth of the previous subsisting decree, no appeal against that decree.
Appeal has been filed, no stay order is still.
In the teeth of the prior decree subsisting in favor of the petitioner, comma, which has been challenged in appeal, but no ad interim order of stay of the decree has been passed. Full stop. Secondly, comma, it is also to be ascertained as to whether the present revisionist petitioner was afforded any opportunity of hearing before grant of police help. Full stop. The revisional application is required to be heard on such issues. Full stop. Accordingly, the petitioners shall serve copies of the revisional application bearing CO number 140 of 2024 on the opposite parties, indicating that the matter shall be listed before the next circuit for hearing as a contested application, comma, subject to being mentioned by the parties before the appropriate bench. Full stop. The petitioners shall file an affidavit of service to that effect on the returnable date before the said bench. Full stop. There shall be stay of operation of the impugned order bearing order number 3 dated May 15, 2024, passed by the learned civil judge senior division at Jalpaiguri in partition title or partition. You have given both numbers.
Actually, in CIS, it is now title.
Oh, actually, it's like that. In title stroke partition suit number 38 of 2024 within bracket COM. Why commercial matter?
No, computer.
As com tak papa this. Title stroke partition suit number 38 of 2024 till September 30, 2025 or until further order, whichever is earlier.
My lord, order number 4 dated 29/7. That is the implementation order.
In the cost title you have given
3 and 4, both is challenged.
Cost title it's not given 3. So 4 is the
3 and 4 in the cost title also, my lord.
Both are dated 15th of May.
No, 3 is 15th of May and 4 is 29/7/2024.
তাহলে যেখানে বলে May order number 3 dated May 15, 2024 as well as order number 4 dated May 29,
29/7
July 29, 2024 passed in তারপর যা আছে 3 এর পর 4টা হয়ে যাবে। নেক্সট, by an order dated July 22, 2025, it had been recorded that it was the second occasion when none appeared for the parties at the time of call. Full stop. Accordingly, a last chance was given to the petitioner to move the matter. Full stop. Even today, comma, at the time of call, comma, none appears to move the revisional application. Accordingly, CO 149 of 2024 is dismissed for default without any orders to cost. Interim order, if any, stands vacated. Next.
Then the last occasion, your lordship was pleased to direct me to serve a notice.
Yes, served a notice. He's appearing. Yes. Right.
For the respondent bank.
Yes.
Lordship, we received the wakalatnama, but we do not have a copy of the revisional application, Lordship.
Give a copy, Mr. Ghosh, come back tomorrow.
It has been served upon the bank. Probably they have not handed over to in any event, but I can hand up.
Learned counsel for the opposite party bank submits that no, তার আগে একটা line record করো। As per previous direction, a notice of pendency of the matter has been served on the learned advocate for the opposite party bank. Full stop. The receipt in that regard is filed today and kept on record. Full stop. Next para. Learned counsel for the bank submits that counsel is not equipped with a copy of the revisional application, comma, although learned counsel for the petitioner submits that a copy has already been served on the bank. Full stop. Be that as it may, comma, to enable the bank to properly represent itself in the revisional application, comma, a further copy of the revisional application be handed over to the learned advocate appearing for the opposite party bank during the course of the day by the petitioner. Full stop. The matter shall be listed under the same heading tomorrow. Tomorrow. Monday, very well. On July 28, 2025. You get some further time. Yes. Thank you. Opposite party.
My lord, as per your lordship's direction.
Notice. Yes.
But there has been
Din.
one mistake on my part. Actually, my lord, I have also communicated by email. Now, the name of the law firm is not Juris. I thought it is Juris. It is IURIS. Now, I wrote it JURIS. So the mail, my lord, email bounced back. And
So this is not a good.
no, by post, it was sent yesterday. If we get, my lord,
When should you keep it? Tell us.
Tuesday, will it be convenient for
Very.
you to check?
Yes, yes, absolutely. An affidavit of service filed today be kept on record. Full stop. Learned counsel for the petitioner in his usual fairness.
The opposite
Oh,
party.
for the opposite parties in his unusual fairness, in his usual fairness, submits that although an email notice was sent, comma, the email ID was erroneously mentioned, and as such, the mail bounced back. Full stop. Accordingly, in order to enable enable the petitioner to serve a fresh notice by email and to await the outcome of the postal service, comma, let the matter stand adjourned till July 29, 2025, when it will be listed under the same heading. The petitioner shall file a further affidavit of service on the returnable day. Opposite party, yes. Opposite party shall file a further. Yes, next. Yes. Yes, Mr. Sharkar, what is the matter? This is that matter, threat matter. Yes. What is the matter?
Order in the
1 to 5, you are appearing for 1 to 5. They are the contesting opposite party. Well. Mr. Das, take your seat. Mr. Sharkar, yes, what is your matter?
My application for amendment of plaint was turned down by the.
Achha, what about 6 to 10? They are not contesting?
They are not.
They filed the written statement initially, but subsequently they are not contesting.
What is the matter about?
My application for amendment of plaint has been turned down by the Civil Judge Junior Division.
1 to 5 filed an objection to that?
Yes. Yes.
Only 1 to 5?
Only one. Only 1 to 5.
That has been rejected. Why? Let us see the impugned order. Mr. Das, you can take your seat. We'll just. You can take your seat. Yes, what is the reason? Just.
The reason is that it is delayed for more than 9 years.
2015.
2015, the incident of 2015.
When did you file the application? What is the stage of the suit?
DW5 has been completed just before argument. Sorry. DW5 has been lost.
Now you have to explain as per the proviso.
Losses, but actually the petition.
What is the amendment? What do you want to incorporate now?
One prayer that on 8/8/2015, there was as per the direction of the learned court, one PR commissioner was supposed to visit the shootland, and just before one day of such visit, the defendant forcefully entered into that land and put some one thalagari or rod and some bamboo pillars in the plot of land. The status of the defendant is they are members of some club, Bhakti-Nagar Netaji Youth Club.
They have a right to give a bamboo to you.
Probably. And they put such things in the land, and they have tried to set up a claim of adverse possession in respect of my land. That is their main case. And at that time, that amendment was not brought into the record. And subsequently, when such fact came
No,
to
your suit is for declaration that you are the absolute and exclusive owner,
of that land,
right? And
permanent
permanent injunction restricting them from disturbance to your possession. Now you say they have entered into possession,
Lordship.
but you are trying to change the complexion of the suit after 15 years.
No, Lordship.
Now, the moment you are being on the verge of being caught, then because your suit is for permanent injunction.
Lordship.
And if they're in possession since 2015 at least, as per your amendment application, rightly rejected.
I can still pay for recovery of possession because 12 years is the limitation, Lordship.
Yes, that you can. Let us see your amendment. You have a point there. Yes. Let us see the amendment application. Relief can even be molded by the court.
Page number 32. My amendment application.
Mr. Das, why should they be permitted to introduce this prayer?
So
Because
that-
in any event, suppose even one day before the decree, if they are dispossessed, it's their case, they have to prove in evidence. I fully appreciate that the evidence has been concluded and all these things. But regarding this possession, I mean, they have sought to introduce a relief. Now, even one day before the decree, before the conclusion of the arguments, if they are dispossessed, they are entitled to seek a relief of injunction, relief of recovery of possession.
About this, but the prayer,
Even court can mold that relief if it is found.
that can be, but the prayer,
Hmm.
I am coming to the page number 34.
34,
The
right?
main prayer.
Main prayer, yes.
Of decree directing the defendant to demolish and remove all the illegal structure.
Right.
That is absolutely barred by under section 137. And if this is being practically put in the amendment, it will hit under article 113. Because relief that has been claimed right to accrue before 10 years back. That
Right.
no recovery of possession is paid for.
Limitation Act din to. Have you got a copy of? Just give me 113. Yes, you are right. You have a point there. যদি এখানে থাকে আপনার হাত যাবে না।
আমি কি দিচ্ছি?
Yes, why suppress him? Give the limitation.
No, the relief is in the nature of recovery.
No, we'll
of
hear you.
possession.
Hear
Relief
you.
is the nature of a recovery of possession. Because
We'll hear you in reply. You have not yet finished with Mr. Das.
Their right to should accrue at least 9 years back. If this release is being put now, that will hit. One.
But why shouldn't this is only copy, you don't have a copy of the limitation act? Limitation. Why shouldn't 64 or 65 apply একটু ফেরত দিন ততক্ষণ? Limitation একটা নিয়ে আসুন। Give it to Mr. Das. 64 or 65 apply? We have got it.
Yes.
Shajan, ছেড়ে দাও।
Yes, for possession 12 years, I agree with the.
That should apply. Why?
But the relief has not been created in that way.
Nature.
No.
Relief is of
A relief for only mandatory injunction. Please.
Demolition, remove illegal structure.
Remove and directing the defendant to remove and demolish.
So as if only there is a structure and that should be removed.
And direction upon the mandatory injunction upon the defendant. So that is absolutely hit. Had it been a prayer for recovery of possession, it could have been a other case.
Although it is not written directly,
No.
recovery of possession or mandatory injunction.
Specific.
The nature of the relief is of such that it is.
Even in the.
You take your seat, Mr. Sharkar.
Yes.
Touch your back to the chair. Yes.
Trial has
Please
been
wait.
comment-
You will have your turn.
Trial has been commenced on 26 May 2017. I am
True.
having the certified copy.
No doubt on that. The other aspect, you are right. The evidence is concluded.
And on that score,
Yes.
detail order. The reasoned order, detail order impugned.
Oh, they had filed and order therein rule 2A also, that was dismissed
Yes.
for non-prosecution, in
Yes.
fact.
Even in the year 2018, when the PW1 plaintiff
Yes.
was on dock, he denied the suggestion that I am still in possession of the property.
You
Even
didn't.
He had the scope to agitate something regarding his disposition.
Acha. He said that he was still in possession. So it cannot be disposition. It cannot be recovery of possession which he is now seeking. Yes. Anything else you want to add, Mr. Dasan? Yes, Mr. Sharp.
So the miss case was with respect to some different incident, not with respect to that incident which I.
No. In your amendment application, you have stated that ad interim order was granted,
Yes.
and in violation of that, they have done this. So miscase must have pertained to that only.
Earlier, there was also another attempt of violation of that order. That miscase was filed. With respect to this 8/8/2015 incident, no miscase was filed.
Maybe, but
That was taken as a ground.
the way you have couched your prayer is not, you don't admit that they're in possession. You still don't admit, and you came to the box, and as Mr. Das rightly pointed out, in 2018, if you have stated after 2015, 3 years after, that you are still in possession, so it's not about possession at all. And in your amendment and your relief, you have said they have made one tin shed structure, cemented pillars, 2 bamboos and whatever, signboard. but you have not stated categorically on that they have dispossessed you. It appears that you are in possession, but they have put those structures over there. And in your relief also, you have asked for a direction to demolish and remove all the illegal structure, not dispossession. You don't admit that you are dispossessed. So this, why shouldn't this be barred under Article 113?
So the nature of the relief, actually at this moment, the relief should have been the recovery of possession. The relief probably has been.
Could have been. Definitely you are right, but unless it was barred by limitation, that is also, you could not file a suit today for this relief.
On this point, I agree, Lordship. If I might.
If you could not file, yes, if your original claim is barred, precisely. Declaration and whatever is there. But you have, in your amendment application, if you said that they had recently done it, then we could have understood. In your amendment application, you allege that they have done it in 2015.
So then liberty will be granted to me.
What liberty? Time-barred relief.
File an application for recovery of possession, for amendment, so that I can pay for recovery of possession of the land based on that aforesaid.
But the nature of the suit will be then changed.
No.
You have
No.
So we won't give any relief to, we won't give any liberty to you. If you are entitled, you are entitled.
So, this relief.
Can it be said to be a continuing cause of action in any manner? No, you are you say that these were done a static act, not a continuing act. They had made the structure and put the signboard in 2015. There's no continuing allegation, no day-to-day cause of action question is there.
In the injunction order.
Permanent injunction, if it was permanent injunction, prohibited injunction, then it would be day-to-day.
There
No.
was a temporary injunction against them.
No. By the hard learned counsel for the parties, full stop, by the impugned order, comma, an application for amendment of the plaint in the suit filed by the plaintiff stroke revisionist petitioner was rejected. Full stop. The two primary grounds of such rejection was that as per the pleadings sought to be incorporated by virtue of the amendment application, comma, on August 7, 2015, comma, that is almost 10 years prior to the making of the amendment application, comma, the defendants 1 to 5 had allegedly come to the suit land and made one tin shed structure by 4 cemented pillars and 2 bamboo poles, as well as fixed a signboard displaying the name of the Bhaktinagar Netaji Youth Club on the pillars. Full stop. As per the said proposed amended pleadings, comma, the defendants have also kept 2 Roth RATH within bracket Thelagari THELAGARI bracket closed on the suit land on the said date. Full stop. Next para. The learned trial judge held that when the amendment application was filed, comma, the evidence of the parties had already been concluded and the matter and the arguments were about to commence. Full stop. No plausible explanation for the delay of about 10 years, comma, till after the completion of the evidence, comma, was furnished by the defendant stroke petitioners. Full stop. Next para. That apart, comma, it was held that the relief now sought to be incorporated, comma, being a decree directing the defendants to demolish and remove all illegal structure and the Roth RATH from the suit land, comma, is by now time barred. Full stop. Next para. Learned counsel appearing for the petitioner submits that the relief claimed is in the nature of one for recovery of possession and is accordingly not time barred. Full stop. Moreover, comma, it is submitted that the learned trial judge also took into consideration the previous dismissal of an application filed under Order 39 Rule 2 capital A by the petitioners, comma, which was on a different allegation than the one sought to be incorporated by virtue of the amendment. Full stop. Since the said miscellaneous case under Order 39 Rule 2 capital A of the Code of Civil Procedure was on a different instance of violation of the ad interim order of status injunction granted by the status quo granted by the learned trial judge, the said consideration was beyond the jurisdiction of the learned trial judge to consider. Push up next para. Learned counsel for the petitioner further submits that in any event, the reliefs can be molded by the court, and in view of the admitted disposition of the plaintiffs, the relief of recovery of person should have been permitted to be incorporated. For some next para, learned counsel appearing for the contesting defendants stroke opposite party numbers 1 to 5 places reliance on Article 113 of the Schedule to the Limitation Act and submits that in view of the relief not being couched as one for recovery of possession, but for demolition and removal of structures on the suit property, the same is governed by Article 113 of the Limitation Act and as such time barred. Push up next para. Moreover, since the evidence of the parties is already concluded, the learned trial judge was justified in refusing to permit the amendment. Push up next para. Thirdly, learned counsel for the opposite party numbers 1 to 5 contents that in the year 2018, that is 3 years after the alleged cause of action for the amendment, the plaintiff's witness asserted that the plaintiffs are in occupation of the suit property, thereby belying the amendment now sought to be incorporated, indicating that the construction of the structures took place in the year 2015. Push up next para. Upon a careful consideration of the materials on record, I find that the order of the learned trial judge was justified. Push up next para. Apart from the fact that the relief is not couched in the form of a suit for disposition, suit for recovery of possession, which might have brought the relief sought to be introduced by amendment within the ambit of Articles 64 and 64 and stroke or 65 of the Schedule to the Limitation Act, making the relief now sought time barred under Article 113 of the Schedule to the Limitation Act, it is also evident that the plaintiffs, despite being fully aware for about 10 years of the alleged construction of illegal structures by the defendants on the suit property, sat tight over the matter and allowed the entire evidence in the suit to be concluded. Thus, there is no plausible explanation furnished for the prolonged delay in making the amendment application. Thus, the rigors of the proviso to Order 6, Rule 17 of the Code of Civil Procedure, within bracket as amended, bracket close, are attracted and the amendment could not have been allowed. Next para. The conduct of the plaintiff stroke petitioners is also deplorable, since it is not clear from the amendment application as to what prevented them from taking out the amendment application throughout the period when the evidence took place over the last about 10 years before filing the amendment application. Moreover, the opposite party numbers 1 to 5 are justified in arguing that since the plaintiff's witness admitted in evidence that they were still in possession in the year 2018, the present proposed amendment cannot be deemed to be a relief of recovery of possession. In such view of the matter, as the learned trial judge took one of the possible views on a preponderance of probability, there is no scope of interference with the impugned order. Accordingly, CO 68 of 2025 is dismissed on contest without any orders to cost. Interim order, if any, stands vacated.
Great.
Sorry. Yes. বইটা কি আমাদের? ঠিক আছে। হ্যাঁ। Yes, who is appearing? 10. Petitioner.
Is the matter?
Who is for this is appearing for the first time?
Yes.
All right.
Volume 2.
What have we challenged?
It's made it in 2 volume, Lordship. Please keep it the volume number 2.
Right.
That bank, respondent bank filed the OA application, section 19 of Sufficiency Act before the trial court. I appeared before the court and
Before the tribunal.
tribunal, yes, sir.
So how is that 227 maintainable?
Lordship, first I have already
DR
used the-
DR80
yes,
is-
DR80 also. Only the thing that I appeared, please come into the page number 393, Lordship. It's a very simple one that has been made the so complication. I'm in a very clean hand. I want to contest the suit. Please come into the 1, 2, 3, third paragraph. There is a direction to serve the paper. It was the order dated.
You are the applicant bank or you are the respondent?
I'm the borrower.
Yeah, so bank preferred an appeal.
Yes, section 19.
19 was allowed in your favor.
I asked for the paper book after appearing before the tribunal.
No, in the DRT, what happened? You won. Bank has preferred this appeal.
Appeal, section 19, invoke the section 19 of Sufficiency Act
Achha.
for recovery of the loan amount and the outstanding amount. I appeared before the court and asked for the paper book.
Yes.
Thereafter, one direction was there. Rather, till this day, that no paper book has been sought, paper book has been given either in hand or by post anyway. And ultimately, the case has been fixed for ex parte. With the observation that I neglected to file the written version before the trial court, tribunal, Lordship.
No, but you must have been served with a copy of the main appeal, the memorandum of or whatever it is called. Paper book, non-service of paper book, how does it matter? You were served with a copy. Why didn't you file an objection?
Only the copy of the intimation that the matter has been filed and the date is fixed for appearance.
No copy of anything was.
No, Lordship.
Let us just.
And that's why this order is there. OA application, that the copy of the OA application should be served to the other side. It has been written and the direction is upon the bank. That has not been complied. Each and every occasion, Junior appeared before the tribunal and asked for the paper book, but that has not been considered. And no order is also there. And it is also not there. Paper book has already been served.
Did you take the point before the tribunal? Before the appellate tribunal?
Yes, Lordship.
No, the appeal is dismissed. What is this?
Appeal is?
Dismissed. Order dated March 11, 2025. What have we challenged here? March 11, yes. At the end, we find that the appeal is dismissed.
Yes, appeal is dismissed.
So their appeal has been dismissed.
My appeal dismissed. I prefer the appeal.
Oh, it was your.
Only I asked for the paper book, so I can contest.
That is not a ground for. So the paper book was not served. I mean, so you had your application, you had their objection. You were the applicant.
Perusing the paper book as the filed by the bank before the tribunal, how I will dealt it.
Your application was with you. Their objection must have been with you.
Nothing is there. Only one intimation that letter has been issued by the registrar of the tribunal that the matter is such and such is fixed on Atho. OA application generally initiated by the banking authority against the borrower for recovery of the money.
Obviously.
That's application filed against me as I am the borrower. After getting the notice from the tribunal, I appeared before the court suo motu and asked for the paper. Direction was given to the banking authority to serve the paper. And ultimately, paper book has not been served. That's why I didn't print the version of that application. Wait. Ultimately, the case has been fixed at the expiry. Thereafter, against that impound order, I prepared the appeal before the DRT. DRT also hold that I have given the sufficient opportunity Yes, sufficient opportunity is something there.
No,
But
it was
until
free.
I
The
get the paper,
no, the section 19 application was fixed ex parte.
it's fine.
It was not disposed of. Still, till not disposed. Against that, you had preferred the appeal. Ex parte here, fixation of.
Direction to the banking authority to file.
Where is the DRT order? Let us see the DRT order. Against which you had preferred. You should have annexed, ideally, you should have annexed a certified copy of that also.
Lordship, this is the page number 399.
399. OA was served on you before the DRT. Even the application was not served.
It is the colloquial practice, only the issuance of the letter to the.
As one thing, you showed me the orders that the paper book were directed. That was in connection with the appeal. Oh, please show me that page again. That page 393, right?
It has been given the.
Yes, right.
Paragraph number 33.
Very well. The present revisional application has been filed against an order whereby the appeal of the petitioner against an order by the Debts Recovery Tribunal, fixing the application filed by the opposite party bank under section 19 of the this is under recovery of debts due to SURFACE. Recovery of debts due to or SURFACE, section 19 of recovery of debts due to of acta blank recovery of debts due to banks and financial institutions. পরে নামটা চেঞ্জ হয়েছে, নামটা পরে দিয়ে দেবো। Recovery of debts due to that act. Yes, please give the name of the statute in a piece of paper. Every time I forget. Yes. So by the said order, the Debts Recovery Tribunal had fixed the ex parte date, despite the revisionist petitioner having allegedly not received any copy of the bank's application nor a copy of the paper books in the matter. For sub next para, learned counsel appearing for the petitioner places reliance on several orders passed by the Debts Recovery Tribunal, including the order dated January 24, 2024, whereby direction of service of paper books on the petitioner was directed. It is alleged by learned counsel that, however, no such copy was ever furnished before fixing the matter ex parte for hearing ex parte by the tribunal. Next para, learned counsel argues that in the absence of service of any copy of the application of the bank or the connected paper book, the hearing which would be given to the petitioner would be illusory, since there would not be any opportunity for the revisionist petitioner to controvert the allegations of the bank. Next para, the appellate tribunal, without going into such aspect of the matter, mechanically affirmed the order of the Debts Recovery Tribunal and dismissed the appeal. Next para, since an arguable issue has been raised on the above questions, the present revisional application is required to be heard on merits. Accordingly, the petitioners shall serve copies of the of CO number 93 of 2025 on the opposite parties, indicating that the revisional application shall be listed for hearing as a contested application before the next circuit, subject to being mentioned before the appropriate learned single judge having determination. The petitioner shall file an affidavit of service before the said court on the returnable date. There shall be stay of all further proceedings in the OA, it has to be, in OA number 60 of 2023, pending before the Debts Recovery Tribunal, Siliguri, till September 30, 2025, or until further order, whichever is earlier. Please just write the name of the act to my office. Thank you. Yes. Yes, sir. For the first time? Yes. Actually, what?
Injunction order is passed by the trial court.
Huh.
That has been challenged. The injunction order was contested on the ground of suppression of.
Injunction, temporary injunction, application allowed. You are the defendant. So you challenged in appeal, appeal has been dismissed.
Yeah. Take or take.
Stay of injunction is not, you know that, Mr. Dutt. Whatever, file an order 39 rule 4 then. That furnishes a ground for 39-4.
Yes, yeah, I will 39 before the.
First court, before the trial.
That has not been mixed the order. But it is found that it has been suppressed, but that has not been. And we actually, there are two meant for contesting.
Against this, you have not challenged.
It was not challenged. Then.
But you got an opportunity ultimately to file a written objection to that. You must have pointed out the suppression there also. So it's on merits. No, temporary injunction. No, you are right. Status quo.
That has been challenged. And appeal was still it is contested.
A at this stage, Mr. Woodward. Let us see where have you argued before the trial court about the suppression? How was it dealt with, the suppression by the trial court? By the first court?
That did it for 39-4.
No, 39-4 was no, that was on a different date.
Different.
No, in the trial court's temporary injunction.
Not
You never challenged the 39-4 rejection, then suppression was suppressed. Suppression ground was suppressed at the order 39-4 stage.
in page number 2.
Ah.
Of the trial court, sir.
This is a partition suit.
This is a partition.
What was the suppression?
Suppression, if that they had stated they had exhausted their share by transferring the land to the by deed.
That was your stand.
That was.
But they have suppressed that and filed this suit. That will be decided in the appeal. We can direct the appeal to be expedited. Whatever you have told your juniors before coming to court, that order will be passed. The present challenge has been preferred against the refusal to grant stay of operation of a temporary operation of a status quo order passed by the trial court while deciding an application for temporary injunction at the behest of the plaintiff's opposite parties, by the appellate court. Push up learned counsel for the defendant stroke petitioner. Defendant stroke petitioners submits that the temporary injunction order was obtained by the plaintiff's opposite parties by suppression of relevant facts. It is contended that despite the plaintiff's opposite parties having exhausted their title in the property by virtue of transfer in favor of the defendants, the learned trial judge failed to advert to such issue on merit while granting status quo. Next para. In view of such suppression, it is argued that the learned judge of the appellate court ought to have stayed the operation of the impugned order of status quo passed by the trial court. On query of court, learned counsel for the petitioners, in his usual fairness, hands over a copy of an order. Have you got a copy of this? I'll keep a copy on record. Hands over a copy of an order dated December 12, 2024, where a similar cause of suppression was raised by the petitioners by way of an application under Order 39 Rule 4 of the Code of Civil Procedure, which, however, was rejected. The said order was not challenged before any forum. Thus, I do not find that any jurisdictional error was committed by the learned appellate judge in refusing to grant stay at the primary stage of the appeal, comma, more so since a grant of stay at this stage would tantamount to allowing the miscellaneous appeal before hearing the parties on merits. Full stop. Next para, keeping in view the nature of the status quo order, comma, which is by way of a prohibitory injunction, comma, in the event an order of stay of operation of the same was passed by the appellate judge at this juncture, comma, the same would render the appeal itself successful at the inchoate stage of admission. Full stop. Thus, comma, I do not find any illegality or jurisdictional error in the impugned order. Full stop. However, comma, keeping in view the fact that the petitioners are suffering from a status quo order for some time now, comma, it is expected that the learned appellate judge, the learned district judge at Jalpaiguri shall endeavor to dispose of the miscellaneous appeal bearing miscellaneous appeal number 5 of 2025 pending before him as expeditiously as possible, comma, preferably within 3 months from the date of communication of this order to the said court. Full stop. In the light of the above observations, comma, CO number 96 of 2025 is disposed of without interfering with the impugned order number 2 dated March 11, 2025, passed by the learned district judge at Jalpaiguri in miscellaneous appeal number 5 of 2025. No arrest to cost. একটা জায়গায় hereby considered and rejected. So part not partially allowed. Oh, cost was to be paid by the plaintiff. It is recorded to be rejected. Recorded to be rejected. Please ensure that immediately a copy is handed over, or if you have another copy, then let it be on record. Right. 12. You are appearing in the matter. 12 also. Yes. What is that?
Yeah, it's peculiar case, this is a peculiar case.
Why?
Kindly come to this number. 31.
First of all, just tell me what is the suit about and whether you are the plaintiff or not.
I am the plaintiff.
Plaintiff in a suit for?
The suit for declaration of title.
And what? Permanent injunction or recovery?
Recovery of person, not declaration of title.
No, recovery of person. Recovered person on the allegation that they are what? Trespassers or licensees or what?
They are not trespassers, they have portfolios occupied our trespassers.
Trespassers, yes. 31.
31 days.
Yes, 31.
Here, on repeated, during the examination of the legal, in spite of immediate objection about the document, which are the photocopies, that when the larger trial went on activity.
How was it proved? How were the documents proved?
They are tendering their photocopies, objection was raised about the content and all, but larger trial court went on.
By the present revisional application, comma, the plaintiffs in a suit for recovery of possession have challenged an order dated December 17, 2024, whereby the learned trial judge permitted several photocopies of purported documents, including letters and notices, to be marked as exhibit with objection, comma, despite such photocopies not being admissible in evidence at all. Full stop. Next para. Since an arguable question in the above regard has been raised in the revisional application, comma, the same should be heard on ought to be heard on merits. Accordingly, the petitioners shall serve copies of CO 138 of 2025 on the opposite parties, indicating that the matter shall be listed as a contested application before the appropriate bench of the next circuit, subject to being mentioned before such bench by the parties whose of the petitioners shall file an affidavit of service on the returnable date before the appropriate bench. You want a stay of the suit. There shall be stay of all further proceedings in title suit number 30 of 2013, pending before the learned civil judge, junior division at Mekliganj, district Kuch Bihar, till disposal of the revision law. Thank you. For opposite party?
Yes,
Mr. Dotto, you are for the petitioner?
But
I'm for the, but
Yes.
I'm for the opposite. Yes, but I'm for the opposite.
Can't see you. Yes, now I can see you, Mr. Dotto.
Plenty of the party. But this application, the application for restoration, when it post title, is application for recording.
Restoration application, restoration of
Yes.
the revision application.
Restoration application.
Mr. Dotto, this bunch was filed together, consecutive now. Not too many.
But who was?
Filed. Yes, Mr. Bhattacharya, vehemently opposed by you, but turned down.
But kindly say, no, I'm not saying that. You also kindly see who was in paragraph 5 and 6.
Who was him?
Was the advocate record or? Who was in? At medical certificate all? This is Somodar Nag. Who was in?
Was he means?
Not advocate record.
Yes.
All medical certificate, not Omura Pandey. Can you see? That has been annexed.
We'll look at the vocal now.
I do not know who has signed the vocal. I got the I know that.
Both of them, Mr. Bhattacharya, you are wrong.
Oh, yes, sir. So then I just thought that is Africa.
In view of sufficient reason for the absence of the learned counsel for the revisional learned counsel for the revisionist petitioner on the relevant date having been made out, comma, can 1 of 2025 is allowed, thereby recalling the order dated July 10, 2025, whereby CO number 15 of 2023 was dismissed for default, and restoring the said revisional application to its original file and number. There will be no orders to cost. There was no interim order. The interim order granted earlier is also restored. But let us hear the revision. You will hear the revision application that will take care of your issues, Mr. Bhattacharya.
But just now, because I have my, there is another bench that will sit at 3. View Myra Justice Fomensen and Myra Justice Smita there.
We'll take it up tomorrow. You have some difficulty.
We'll do one thing, my lord. But
Yes.
take it at 29. For other reason, not for other reason. Other reason, my lord.
Are the material reasons?
Yes, my lord.
It's very candid. We'll keep it at 29. On the prayer of the opposite party, the revisional application is adjourned and shall next be listed on July 29, 2025 for hearing.
Yes, sir. I'll get to it.
But Mr. Dotto was very fair. He was ready with the main matter also. So he's
I
not
know,
trying
but
to
I
take
think that
advantage
short-
of interim order.
No. That's what matter. I have a matter just now. I saw that calling. The Pathat matter, that item 3,
Yes, yes,
that
he's
will be
very
called
fair,
on just
very
now.
fair.
That
Very
is
fair.
why. Otherwise, I was also ready. I'm
Very-
grateful, my lord. Okay.
Yes, next. Participate. Yes. Right. You are for the opposite party, Mr.
Not for the owner, respond number 2 is. I think so for the conclusion of the
Ah, no, you have to serve the owner also, both the. File it. You have checked up, both have been served. Please check up before handing up. Whether service has been effected on both. Item 14 to it. Board hai. Yes. This is an appeal against what? MSCC? What is the delay? 1,000 days. When was the?
1882. 1882.
Very well. When was the order passed? The award passed. Date. February 2020. So what is the limitation period? 90 days.
90 days.
90 days. 90 days. So after lapse of 1 month, 1.5 months, COVID started. When did you file this appeal?
May 2020.
1 for 2024.
This year,
What?
25.
No, what happened from 1st April 2022 till these 3 years?
Diagram of my application.
3 years delay. Even after COVID, we are not taking into account the COVID period. 5, 6 are COVID. No, what happened after March 2022? The COVID relaxations were given up to 31st March 2022. What happened from 1st April 2022 till 2025? What is that? Five something else. 5 years of COVID.
COVID.
Up to 6 COVID.
6 COVID.
6 COVID. Yes. Irregularity in court proceeding.
Different cases, connected the same cases, and for that the tribunal had the knowledge judge, the tribunal action district judge, fast track, second court judgment was avoided to proceed and to give permission for handing over the federal copies of the awards already passed by the tribunal. More so, when the court.
You have applied for certified copy on 26th of March 2025. So what was the fault of the tribunal? You could have applied in April 2022 after the COVID period. You have to apply. You applied after 3 years. Why blame the tribunal? Not showing interest, departmental staff to send case. What nonsense is this, sir? You have stated that departmental staff of the tribunal was not showing interest to send the case records to the concerned record rooms. You did not apply for certified copy. Why will they show interest in sending records? If this is accepted, then unnecessary allegations against the tribunal staff are being accepted. Why? Just because they are not present. Nothing was in a mess. Everything happened. After COVID, March 2022, everything became normal. Oh, once you blame the tribunal staff, then you blame the law clerk of the applicants. All those are not being heard before us, and you are blaming going. Tomorrow, your client will prefer an appeal against the rejection, which will happen right now, against that, and blame you first. Your client is the habit of blaming people. Law clerk at fault, tribunal staff at fault. Only you are a Puritan. No, not you. I mean your client. Sorry, this even then some amount was awarded to you. No.
Yes.
You are trying to, I mean, tax the insurance company dry. No. No explanation. We could have been lenient unless these allegations were no. We cannot accept this. No question of your apologies. You have already said what you had to say. No. No beneficial legislation. No. Understood, appreciated. Some amount was awarded to you. What was awarded to you? 15,23,000 was given.
They are not challenging the amount.
No, we are saying that 15,23,000 has been paid to you, not that you are hand to mouth. No, the award says the petitioners by separate within 60 days, failing which carry interest at the rate of 9%. Yes.
So no interest has been awarded.
During the pendency of that application, interest. No, interest pendentility. I mean, during pendency of the application, yes, subsequent interest has been given, if not paid within during subsistence of the claim.
That has not been done. Here, the default clause has been given.
Yes, there is a point in what they're saying.
But we have to be concerned with the limitation.
No, but this section 5 cannot be allowed.
There is a violation of the mandatory provision, Lordship. Kindly consider, Lordship.
There is no explanation at all. You cannot come whenever you wish. After even after the COVID period, you came after 3 years. And the explanation you have palpably, you have said that the staff, departmental staff, you have blamed everybody. Head clerk, no. No, sorry. Come to para 8, there you, then you start with the law clerk of the advocate.
It happened, these people are rusty people, they don't have any idea about the law. Even only they are getting this benefit after the establishment of the scientific lordship. Others, they do not, they have to go to this lordship. Can you consider this lordship? Fiction has been violated, lordship.
No. What do the sons do? 1 and 2? 26 and 24, not so.
They are just unemployed, they are looking for job, right?
Yes, what do you say? Really rustic, maybe rustic people.
We cannot
Take a,
consent, your consent to.
if a strict view is taken, your learned friend is right. I mean, and these are the brainchild of him, not his client. His client, not his client. But then these have to be accepted. If we allow your application, these grounds have to be accepted. File a supplementary affidavit. Make out another story. File a supplementary affidavit. You have contact with your clients. File a supplementary affidavit. Spend tonight over a news story, and this will remain, but add some other ground. No, need not skip over the paragraph. Please do whatever you have to do. I will give you time. We'll keep it on Monday. In the meantime,
Monday.
Tuesday then.
Wednesday. Monday.
How soon can you prepare that affidavit, supplementary affidavit? By tonight. We'll keep it on Friday then.
Friday. I have to accompany my daughter. Friday, Monday, Tuesday.
You come back when? Tuesday?
Wednesday. I will come back Tuesday.
Wednesday very well. We keep it on Wednesday. Wednesday is 30th of July. On the prayer of the petitioners, leave is granted to the petitioners to file a supplementary affidavit to the application for condonation of delay with an advance copy to the learned advocate for the opposite parties. The matter shall next be listed on under the same heading on July 30, 2025.
Great.
Give an advance copy to them. Put in something which we can accept. Yes. Similar. Grounds are similar. So is it because of the previous view taken by the court or? Very well. So when should you keep it? Tell us. All right. Learned counsel for the petitioner submits that the affidavit of that the service has been completed. No. That the service has not yet been completed. So accordingly, on the prayer of the petitioner, let the matter stand adjourned till July 28, 2025. We are putting it on Monday. Monday? In one day, nothing will happen. Yes. You will be available on Monday. Yes. Let us see paragraph 6. Similar. On the prayer of the petitioners, you are for the opposite party.
The respondent.
You have got a copy of the section 5. On the prayer of the learned advocate for the petitioners, leave is granted to the petitioners to file a supplementary affidavit to the condonation of delay application, an advance copy of which shall be served on the opposite parties. First up, the matter be placed in the list under the same heading on July 25, 2025, Friday, day after tomorrow. Please give an advance copy to him. Yes. Please give your name, appearance. Yes. By an order dated July 22, 2025, it was recorded that the petitioners were repeatedly being absent at the time of call. Full stop, next para. Even today, comma, none appears to represent the petitioners at the time of call. Full stop. Can to the key. Accordingly, Can 2 of 2025 is dismissed for default without any order as to cost. The revisional application be placed in the list on July 28, 2025. Canটা dismiss for default করেছি, revisionটা alive রেখেছি, ওটা সোমবার দেবেন। Yes. Petitioner. One petitioner or several? On the prayer of the petitioner, the matter is urgent for the day. For the day. Give your name, ma'am. Yes. Yes. Petitioner. So what? You move the matter. What is this application? Appeal was admitted. Right? Oh.
On Monday, I will have a fresh notice to the office.
Very well. So we'll keep it in the next circuit. By Monday, you can do it. On the prayer of learned counsel. No, you can serve within that. On the prayer of learned counsel for the none appears for the respondents at the time of call. Full stop. Learned counsel for the appellant, comma, in his usual fairness, comma, submits that he be permitted to serve a fresh notice on the respondents. Full stop. Accordingly, the petitioner's appellant shall serve a fresh notice on the respondents, comma, directly and or through their learned advocates, intimating that the matter shall next be listed on July 28, 2025, and file an affidavit of service to that effect on the next date. You serve either directly or through their advocate, file an affidavit of service on Monday, we'll take up the matter. Yes. That is for doing the matter or throwing at the court. Yes. Prepare, who prevents you? This appeal has been admitted. So what is appearing now? This is item 20. Then no application is pending. This is for hearing. What is this? But what about the other side? Give a notice, come back on Monday. This is the insurance company and the owner. Oh, they have received, no, notice of the appeal has been served on them. Nobody is appearing for them. No, those have been allowed. Appeal has. No, but service of notice of appeal has to be there.
With that, can happen.
No, that is not through court. It has to be served. You don't find any office report regarding that. This hearing has been received from trial court records received. Yes.
So that we have served appeal, memo of appeal, as well as.
That is not a good service. So notice of appeal has to be served through the court. You have to put in requisites, and was there in direction? Let us see.
Paper also, I obtained.
No, everything you have obtained, but through court it had to be served. Notice of appeal had to be served through court.
In spite of having this, receiving the notices, they have not appeared. In this-
You served a copy of the memo also.
Yes, sir.
What is the appeal about?
Yes, claim now.
By an order dated April 8, 2025, comma, a learned single judge, a coordinate bench of this court had directed the appellants to serve notice on the respondents along with a copy of the memorandum of appeal, which was duly complied with. Full stop, next para. Despite such service, comma, none appears for the respondents at the time of call. Full stop. Accordingly, the appeal is taken up for hearing in the absence of the respondents. Yes, what is the matter? What is your ground? Why should it be enhanced?
The amount, the income of the disease, that was only 5,000.
Hmm.
But it was, national income, it has been fixed, since earlier apex orders, that 6,000 and above, now it is taken as 6,500.
Have you got a copy of any of the judgments? Because I am not a regular in the motor accident field. Bring those judgments.
Yeah, tomorrow,
Yes, come with all the judgments because I need to be, I'm not a regular in this branch. Well, at this juncture, comma, যে পর্যন্ত বলেছি তারপর, at this juncture, learned counsel for the appellants seeks to rely on certain judgments. Full stop. In order to enable the appellant to rely on such judgments, let the matter stand adjourned for the day. Come back tomorrow with the judgments. We'll
I shall, come with all the data.
next matter also, you served copy and yes. আচ্ছা আগেরটাতে একটা লাইন অ্যাড করে পেপার বুকস ফাইল টুডে বি কেপ্ট অন রেকর্ড দেখি একবার ওটা ফাইলটা হ্যাঁ রাখুন সেম অর্ডার এক্স্যাক্টলি সেম অর্ডার similar points are involved in both different the other is interest Uday Sarkar. Yes.
22, my lord, I am appearing, my lord, virtually.
Yes.
My lord.
Yes. Yes.
My lord, in item number 22.
Yes.
I am appearing on behalf of the CGST department. My junior is there.
Yes.
My lord, both the matters, 22 and 23 are of hearing matter.
Yes.
Affidavit in opposition has been filed. They have filed the reply to the opposition, but
Yes.
I am not finding the reply to the opposition in my brief. So kindly fix
Mr.
it.
Sharaf
after
must have
tomorrow.
planted some of his men in your office.
My lord.
My lord, there is nothing, my lord.
Mr. Sharaf must have planted some of his men in your office to remove those copies. Anyway. That,
Kindly
not
fix it
registered.
Friday.
Friday. Mr. Sharaf, what is your difficulty on Friday? If you don't have any difficulty, we'll take up on Friday.
My lord, I don't have any difficulty, my lord, but this has been adjourned so many times, my lord, and I am not going to submit anything, my lord,
we have
beyond
not
my
paid for
petition.
time. We have not paid for time.
No, Mr. Bonik, Mr. Sharaf says that he won't be submitting beyond his petition. So even
But,
without the reply, we can proceed.
But all is
I have
point
to
of
go
law.
through.
Mr. Bonik is not ready, Mr. Sharaf. It's very
Yes,
evident.
my lord.
He doesn't
Then
want to be
kindly leave it
recorded.
on Friday, I will furnish a copy to him. Or
I
it
think
can
that
be
will be
kept
better.
tomorrow
Yes,
also,
yes,
my lord.
yes. Please provide me a copy, another copy,
Yes,
please.
he'll do it. His learned junior is here. So tomorrow,
Yes.
any difficulty, Mr. Bonik?
Tomorrow, it will not be possible. At least one day accommodation is required. Friday, any time, my lord.
Mr. Sharaf, back to your court.
Yes,
Friday,
quote unquote.
My lord, Friday, my lord, one more matter I mentioned, my lord, with this 1516.
Very well, then that will also come. So
Yes,
this will
yes,
also
there
come.
are three
Very
matters. Three
So they are
matters
all
are similar.
analogous, my lord.
Oh, analogous, actually.
Analogous, right, right,
Please,
my lord.
I'm requesting your learned junior to give that number again so that it's.
Yes, yes,
Please give the other
1518,
number
I
again.
think. 1518.
Oh, acha. We have requisitioned, our officers have requisitioned 3 files. One has not come, that's why it was not given. We'll try to put it on.
Yes, yes. All the three matters are of same.
No, my lord, Friday, I have some difficulty, my lord. Kindly keep it tomorrow, my lord. Friday, actually.
Tomorrow it will not be possible.
Very
my
well,
lord.
day after tomorrow we'll give it. On the prayer of the respondent, the matter is adjourned till July 25, 2025, Friday.
Grateful.
Yeah,
Grateful.
please give whatever copies they don't have. You are Mr. You are Mr. Mr. Mittal, please give whatever copy they don't have to them so that on the next occasion this does not happen.
Yes. Grateful.
দুটো হয়ে গেল স্যার।
Careful matters.
Thank you.
Same matter.
Yes, yes.